nothing, ladies and gentlemen. We would be nothing. All right. Hello, towel friends on the Towel YouTube. You know what that means. Roll the intro.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody to Funky Town.
You heard the towel. That's it. That's a melody to Funky Town. Look at me. I'm a little towel. How's everybody doing? Everybody being a little towel? Everybody going along well? I'm thrilled to hear it. Hello, Colleen Henry and Buck Towel. Buck Towel, the ever-vigilant guardian of the American Midwest. It is so good to see you. Buck Towel, have you been protecting Colleen Henry Towel? Is everything good? Everything's good? Very good. I won't compromise your secret position in NORAD, I promise. Hello, it's great to see you, Ange and Elijah Towel. Oh, ladies and gentlemen, I am thrilled to have you with me. I hope you know that I have two things for you today. One, at 3 p.m. Eastern, just over 2 hours from now, we're going to watch the Donna Adelson sentencing hearing. But before that, we are going to talk about Towel's new proposal. Towel worked hard. All right, this is a new proposal for a statute that would reform the special prosecutor appointment process in Massachusetts. And you might be saying to yourself, Towel, I'm not surprised at all that you did this, but are you going to talk us through it so you can explain what it means? I'm absolutely going to do that. I even got one of my infamous Towel read-alongs set up for you so that I can pause it and explicate it as I see fit rather than having to read thousands of words. And you maybe, I wish Donna Adelson's sentencing hearing is what we'll be focusing on today, along with this important bill. So, bill first, we're going to do some analysis, then we're going to go immediately into George's closing. We're not going to be able to watch the whole thing, just so we're all on the same page heading into the sentencing. Hello, Allie and Bro, I'm a little towel. And then also, I have gift memberships to give away. All right, I'm excited about that. We are going to have a membership parade at some time during the reading of this new bill that I'm proposing to reform the special prosecutor appointment process in the great Commonwealth of Massachusetts. So you sit around, you may well get one of these wonderful Towel gift memberships. I have 10 to give away, going to give away 5 today, and maybe 5 at another point in time. Now, we also had a Towel friend who sent over a very wonderful picture of their Towel cat. Now, the Towel cat's name is Trump. So, of course, I'm going to do my best to bring that up for us if our Towel friend shows up. Yes, that was Carol Ann. So if Carol Ann is here at some point today, we will be looking at the greatest Towel cat you've ever seen, named Trump. All right? It's great. It's adorable. So, let's do it. We have our special read-along voice. I have a statute I want to propose. All of our Towel friends are here. Let us begin. We are a little bit early, as I mentioned, for the Donna Adelson sentencing, but that's okay because we're going to learn about statutory construction. I'm not a lawyer, I'm a towel, but I want to petition my government for the redress of my grievances. No, Allie, Towel has been having some health issues, so it's more, I don't have that strength, that multi-towel strength to do trivia right now. I wanted to do it this weekend, then I slept 16 hours a day. When Towel's health gets to a position where he's feeling a little stronger, we absolutely will play some trivia. We all know that Bossy Texas Chick and Bella are never going to let us forget about trivia, and we will play again soon. All right, but today, things to learn about. Who's ready to learn? I could offer you a quiz on statutory construction, I suppose. If you all are intent on learning retention modules, we can do that. But all right, let's do it. So, your reward for listening to this is you're randomly going to get gift memberships, 5 of you, during the reading. This will tell you all you need to know about why I'm proposing this, what the problem is, and how we're going to fix it. I'm interested in your ideas. How can we make this better? How can it be stronger? I think it has very good construction, okay? It has layers of redundancies. Even if the Attorney General recuses and the Governor recuses, there's built-in provisions to go up to the SJC. So I want to hear your input. Is there enough enough independence asserted for the special prosecutor, the special investigatory unit, and the victims' witness advocates involved. Massachusetts is one of only 10 states in the United States that does not have really an in-depth statutory framework that takes the special prosecutor process outside of the district attorney's office that may have a conflict on a given case. And I want to build one. And you may be saying to yourself, sir, you also help to design, implement, and update the adult use and medical use law in the Commonwealth. Is that why you kept saying to people, do not mess with me because I'm going to reform the statute if I find that you're abusing the vulnerable under color of law? Yes. Yes, I said it to you all hundreds of times. Now we're going to do it. All right, we're going to do it. You're going to watch. It's going to be a budget amendment. It might not pass as a budget amendment. I think it should, frankly. I don't care. I'll get it introduced with sponsors at the start of the next legislative session. We have 2-year terms in the Commonwealth. You don't understand. I will get sponsors. I will get the leadership to sponsor it. I will get it a committee hearing. I will get this bill on a bipartisan, bicameral basis passed into law. Hello, Shaka's disbelief. You came at a wonderful time. I am extolling the virtue of legislative change to fix systemic breakdowns that facilitate the exploitation of the vulnerable under the auspices of prosecutions where there's too much inside baseball, too much wheeling and dealing, too much Jen McCabe, too much Michael Morrissey, too much Brian Tully, too much Kate Peter, and it undermines the pursuit of justice for those who are truly harmed. And in turn, I've created this law. What did you think was going to happen, all of you? Not you in the chat, but all these people. They thought they were just going to do this because there's holes in the law. Absolutely not. Yes, Allie, and don't worry, we will watch some of Georgia's wonderful closing from Donna's trial after we go through this statute. But yes, so I'm very interested in feedback, and I think I've designed this statute in a way that will prevent abuse and exploitation of the special prosecutor process going forward, and in a way that reflects some of the sort of subtle nuances with the overlapping concentric social circles of power, which so perniciously, and in my opinion at the expense of the vulnerable, did things like leak Lindsay Catani's unredacted cell phone extraction, Brian Tully, with Nick Garino's help, and Kate Peters' help, to help Jen McCabe take attention off herself, in my opinion, in April of 2024 at the start of the first Karen Reed trial, or other things that were completely, in my opinion, inappropriate, like Kate Peter handling evidence and submitting it to the grand jury, and all these things, all right? It was basically, you had a situation from October of 2023 when Michael Morrissey recused from the prosecution of the Aidan Kearney and Karen Reed cases forward, where Kate Peter and Brian Tully were in effect still allowing the Norfolk DA to be involved because Kate Peter and Michael Morrissey speak, as does Tully and Michael Morrissey, and then for some reason Jen McCabe was involved in all this, talking to Tully and talking to Kate. That's why I think it's hard for people to understand this. To do this kind of reform and to do this kind of work, you can't show fear or favor. You can't say, oh, well, because I want Karen Reed to get convicted for what she did with John O'Keefe as to John O'Keefe's death, therefore I'm just going to ignore everything bad that Brian Tully and Kate Peter did because Brian Tully's unit investigated Karen. That's ridiculous. First of all, that unit doesn't exist anymore. I think Fanning's the only one left, and that could be for a reason because they want to know where he is every day in case they want to arrest him, related to the Birchmore cover-up, because Fanning was the one who wrote that report absolving Matthew Farwell initially of responsibility for Sandra Birchmore's death. Anyway, this is which I don't mean to just gloss over, but there's so much going on. This is a systemic issue that rotted our justice system from the core, and it came at the expense of pursuing impartial justice for the victims in these cases. No one is saying here that these two things are mutually exclusive. The alleged bad acts of Aidan Kearney, etc., and then the systemic rot within the Norfolk DA and the special prosecutor process and the MSP. Two different things. And then also, I'm not saying that every part of the MSP is rotted to the core or that every part of the Norfolk DA's office was rotted to the core. It's just there were a lot of conflicts of interest that were facilitating things behind the scenes that came at the expense of our justice system, at the expense of the vulnerable and the victims, and at the expense of people who weren't politically connected. That's what we have to reform. That's what I reformed at the CCC, and by God, I'm ready to reform it here. But yes, hello, Dave. So we're not hello, friends. We're not exactly sure on the Donna Adelson sentencing. I think it can be life without parole or life with parole. It's probably going to be life without parole. We absolutely will be keeping an eye on that as we get closer to 3 p.m. Eastern. But for now, let's listen. Let's learn and let's be erudite, informed, and cogent little towels. I'm also tired, so that's why we're going to listen to this special voice read this. Let's do it. Come on now. Come on, you can do it. I have faith in you, little towel. It was working well earlier. Sometimes it needs a second when it's multi-toweling. We're giving it a second. You can do it, little towel. Come on now. Come on. You can do it, little towel. I have faith in you. Oh, it's because I'm using the more complex engine. All right. Well, we're going to give it a second. We're going to give it a second. All right, here we go. You can do it. Come on now. I can switch the voice if I
Grant Smith Ellis.
Good morning.
No. We are not going to have these delays. I'm going to have to switch to a different voice. Sorry. Hold on. I got a plan. I have a plan. All right. We're going to do English, United Kingdom. How's this one?
Read Aloud is a Chrome and Firefox extension that uses text.
I don't love it, but all right, fine. I just don't want to read right now. It's
Grant Smith Ellis. Good morning. Massachusetts lacks a comprehensive statutory framework for appointing special prosecutors in cases of the recusal, leading to ad hoc practices that can perpetuate conflicts. Under MGLC 12, 20 and 20C, DAS have broad authority to appoint special assistant district attorneys, often private attorneys, at their discretion, with powers equivalent to regular assistants, but this keeps the appointment within the DAS office, even after recusal, which undermines neutrality. In practice, when other recuses, i.e., due to personal ties, office-wide bias, or public pressure, courts may appoint a special prosecutor under inherent supervisory authority or ethics rules, i.e., MAS. Our Professor. See 3.8 on
now,
prosecutors.
This is interesting because this means, at least according to some of the research, it's possible for judges to appoint special prosecutors under superintendency powers. Obviously, I'm thinking about that in the context of what's going to happen in the ongoing Aidan Kearney and Lindsay Gattani cases, where the Judge Doolin has ordered within probably 20 more days a prosecutor from the AG's office or an independent prosecutor appointed. So that's an interesting thing to keep in mind.
Special responsibilities.
Yes, bossy Texas chick. Hold on, let me try one of the other voices. I really liked the voice I had earlier. It just wasn't, like, cooperating. So let's try that other voice one more time, all right?
Grant Smith Ellis.
Good morning. Massachusetts lacks a comprehensive statutory framework for appointing special prosecutors in cases of DA recusal, leading to ad hoc practices that can perpetuate conflicts.
Under MGLC.
Oh, I really like this voice, but it takes too long to load. All right, we're going to try one of the other male voices. So the good voices, they require a lot of processing power, and I'm doing a lot of things right now. So let's try a male voice from the UK.
Read Aloud is a Chrome and Firefox extension that uses text-to-speech technology to convert web page text to audio.
All right, let's do it.
Grant Smith Ellis. Good morning. Massachusetts lacks a comprehensive statutory framework for appointing special prosecutors in cases of the recusal, leading to ad hoc practices that can perpetuate conflicts. Under MGLC 12, 20 and 20C, DAS have broad authority to appoint special assistant district attorneys, often private attorneys, at their discretion, with powers equivalent to regular assistants, but this keeps the appointment within the DAS office, even after recusal, which undermines neutrality. In practice, when other recuses, i.e., due to personal ties, office-wide bias, or public pressure, courts may appoint a special prosecutor under inherent supervisory authority or ethics rules, i.e., MAS. Our Professor. See 3.8 on prosecutors' special responsibilities, often drawing from the Attorney General's, AG, office or private bar. However, this can involve the recused DAS input or result in delays, as seen in ethics opinions allowing private firm attorneys as special prosecutors but without standardized conflict checks. As a result, I feel we need an independent body to make those decisions, as the Lindsay Gaetani and TurtleBoy case, along with the Karen Reed and John O'Keefe case, makes clear. In turn, I have done some research. The last attempt to reform the special prosecutor process in the Commonwealth occurred in 2014 via Bill H. 1227. It was sent to study and never brought up again. Using that proposed bill as a framework, and after looking at how this process functions in other states, I have begun work on draft legislation that will either be submitted as a budget amendment or a formal standalone bill at the start of the next legislative session. I will work on getting sponsors for the legislation, including in leadership across both houses, but I am looking for input on the wording as proposed below. Please feel free to add your input below. I call it, a law for the voiceless. Formal title, an act standardizing the appointment of special prosecutors in cases of district attorney conflicts. Current law and the issue. Massachusetts lacks a comprehensive statutory framework for appointing special prosecutors in cases of the recusal, leading to ad hoc practices that can perpetuate conflicts. Under MGLC 12, 20 and 20C, DAS have broad authority to appoint special assistant district attorneys, often private attorneys, at their discretion, with powers equivalent to regular assistants, but this keeps the appointment within the DAS office, even after recusal, which undermines neutrality. In practice, when other recuses, for example, due to personal ties, office-wide bias, or public pressure, courts may appoint a special prosecutor under inherent supervisory authority or ethics rules, for example, Mass. R. Professor. See 3.8 on prosecutors' special responsibilities, often drawing from the Attorney General's, AG, office or private bar. However, this can involve the request's input or result in delays, as seen in ethics opinions allowing private firm attorneys as special prosecutors but without standardized conflict checks. The 2014 H.1227 bill's proposed AG preliminary investigation and governor appointment was a targeted fix for police cases but never passed, leaving a gap for broader application. Laws in other states. States vary in how they handle special prosecutor appointments to address the conflicts, for example, personal, institutional, or political biases, with about 40 states having some statutory mechanism. The majority rule, used in 25 states, like New York, Connecticut, New Jersey, and Maine, vests appointment authority in a state-level executive actor, typically the AG or governor, who supersedes the local via ad hoc, case-specific, or permanent units. This removes local conflicts by transferring jurisdiction statewide, often triggered by recusal, use of force incidents, or public corruption. For example, New York, majority model the governor's 2015 Executive Order 147, codified under Executive Law 63-2, mandates AG supersession for police civilian deaths, with a permanent Special Investigations and Prosecutions Unit handling investigations and public reports on non-charges. Local DAS must yield files, ensuring full removal from the process. Connecticut, Con. General Stat. 51-277 requires the chief state's attorney to appoint a prosecutor from another judicial district for police killings, balancing efficiency with independence. The minority rule, used in 15 states, like Hawaii, Wisconsin, Illinois, Utah, Georgia, and California, avoids full supersession, opting for oversight boards, independent investigators, or procedural tweaks, for example, mandatory reporting without appointment. This retains some local involvement, which can lead to parallel probes or confusion but emphasizes community input. For example, Hawaii, a 2016 law creates an AG-hosted law enforcement officer independent review board, 9 members, including community reps, to review deaths and recommend, but not mandate, actions to local prosecutors. Illinois, post-2014 Laquan McDonald shooting, a judge appointed a special prosecutor amid petitions, but without statutory mandate, resulting in overlapping federal/local reviews. The federal framework. Federal courts emphasize prosecutorial disinterestedness, neutrality, under due process, 14th Amendment, and separation of powers, but grant states broad latitude to design appointment processes as long as they avoid arbitrary bias or executive overreach. Key precedents. Young v. United States ex rel. Vitonit Fils, S.A., 481 U.S. 787, 1987. The Supreme Court upheld courts' inherent authority to appoint private special prosecutors for criminal contempt, to enforce orders without executive dependence, but required them to be disinterested, no financial or personal stake, and, ideally, after referring to the U.S. Attorney for declination. This reversed convictions tainted by a biased appointee, the civil plaintiff's lawyer. Implications for states: courts can appoint specials to avoid conflicts, but must prioritize neutrality. States should build in referral steps, for example, to AG, to minimize judicial involvement and ensure due process. Morrison v. Olson, 487 U.S. 654, 1988 upheld judicial appointment of independent counsel for high-level executive probes, rejecting appointments clause challenges as the roles were inferior officers with limited tenure. States can similarly empower courts or executives without federal interference. Other cases, for example, Donziger v. United States, 2024, affirm court appointments under Fed. Arcrim. P42 for contempt but stress avoiding interested prosecutors. States aren't bound by federal executive models, for example, 28 CFR 600.1 for special counsel, but must ensure appointments don't violate equal protection or due process by creating systemic bias. Proposed bill, an act standardizing the appointment of special prosecutors in cases of district attorney conflicts. An act standardizing the appointment of special prosecutors in cases of district attorney conflicts. Be it enacted by the Senate and House of Representatives in General Court assembled, and by the authority of the same, as follows. Section 1. Chapter 12 of the General Laws, as appearing in the 2024 official edition, is hereby amended by inserting after Section 27 the following sections. Section 28. A. As used in sections 28 to 28G, inclusive, the following words shall have the following meanings unless the context clearly requires otherwise. Applicable case, a criminal proceeding in which, I, the district attorney has formally recused pursuant to Massachusetts Rules of Professional Conduct Rule 1.7 or 1.11, or Rule 3.8 for prosecutorial duties, as informed by commentary under Rule 308, or 2. A court has ordered appointment of a special prosecutor due to a conflict of interest. Conflict of interest, a circumstance in which a reasonable person would conclude that the district attorney's personal, financial, institutional, or professional interest presents a substantial risk of materially limiting the district attorney's independent professional judgment in the proceeding, including but not limited to direct relationships with parties, witnesses, victims, or law enforcement agencies involved, provided, however, that mere political affiliation shall not constitute a conflict unless it involves a material financial or personal tie. Special prosecutor, an attorney licensed to practice in the Commonwealth, not holding any elected or appointed judicial or prosecutorial office, appointed under Section 28B to investigate and prosecute an applicable case, independent of the recused district attorney's office. Special Investigative Unit, a team of no fewer than 3 and no more than 10 investigators, appointed under Section 28B, consisting primarily of investigators certified by the Department of Criminal Justice Information Services and sourced from the Office of the Attorney General or federal agencies with consent, but which may include certified independents vetted by the Attorney General excluding private investigators who have worked for the recused in the past 5 years, provided, however, that the unit shall exclude any members from the local police department involved in the applicable case or any member of a unit of the Massachusetts State Police detailed, currently or previously, to the recused district attorney's office. Victim /
Just so everyone understands, what this does is a law, you define the terms, and then we're going to go into the sections of the law to talk about it. The other thing is people were asking about the budget. So it's you have to get an appropriation if you're a DA. Every year they have their budgets. It's a lot. It's tens of millions per office, but you still have a budget. And if you run up against budgetary constraints as a DA, your options are: 1, go to the legislature to ask for more money, which Michael Morrissey tried to get $1 million extra for the Reed prosecution, couldn't get it. And then 2, you can also use your forfeiture funds, but forfeiture funds, civil forfeiture, are capped. You only can use what's there, and the DA, it doesn't have much of its forfeiture budget. So what I try to design, and we'll get to the way that they're paid, is you're not just budgeting for the special prosecutor, the lawyer that you need. And you need a good lawyer. If you're bringing in a special prosecutor, it's for a serious case. You need a good lawyer. So they're going to bill $250 to $400 an hour, okay? And then you need to budget for all their experts and their private investigators and their witness testimony and their evidence collection. You need all of that budgeted for. You got to think about this from a policy perspective. We're not trying to handcuff the prosecutor here. We're trying to empower the prosecutor. We're trying to take away the
witness
prosecutor's
advocate, a designated
conflict of interest. And then we're building redundancies. You're going to see the redundancies here, where it's not just the special prosecutor who's got to be cleared of conflicts. It's the investigative unit that gets assigned and the victim's witness advocate. So let's keep listening. But yes, I hear you about the budgetary constraints. Mind you, the law that I helped write, the cannabis law, and implement, I am, along with my friends, responsible for generating hundreds of millions, billions of tax revenue in this state. And if you don't believe me, look at the amount between 2018 and 2025 that the adult use industry has generated in tax revenue for our 354 local cities and towns and for the state. You are talking $7 billion in taxable revenue at 17 to 20%. It's complicated. It's a 6.5% sales tax, or roughly, and then a 12% excise tax, and then a 3% option, up to 3% local tax option. We are talking every year $250, $270, $290 million going to our cities and towns, going to our law enforcement, going to pay back debts for the big dig, going to empower substance abuse, going to empower our schools, going to empower communities that need uplifting through local business investment. How do I know that? Because 15% of the excise tax is used via a dedicated levy to fund small business grants up to $500,000 for people trying to enter the industry, so it doesn't become monopolized. I know very well the state of the Massachusetts tax picture, and I'm saying I think I have, in my opinion, more than earned the ability to advocate for empowering special prosecutors with a certain amount of budgetary allotment, notwithstanding the hundreds of millions of dollars of tax revenue that I have helped to bring in for this state over the past few years, but purely on a policy basis. And I'm not disagreeing with Bossy Texas Chick, I'm just explaining why I wrote it this way. But this is my proposed law. We can always amend it. This legislature can amend it. They can do whatever they want. But let's take a look at my proposal, and thank you for all your questions. I like answering them. I'm a towel.
Advocate providing support services to victims or witnesses under Chapter 258B, whether employed by a governmental agency or a non-profit organization. B. Sections 28 to 28G, inclusive, shall apply to applicable cases arising on or after the effective date of this Act, and to ongoing applicable cases where a recusal or court order has been issued on or after said date, provided, however, that for recusals noticed prior to the effective date, the provisions shall apply 90 days thereafter.
So the way I tried to write this was, if cases are ongoing where there's recusals that were already entered or ordered, you have 90 days as the Attorney General or the Governor to invoke this process and do it, and it applies. So this applies to ongoing cases. They can be subject to the process I'm about to lay out. Now, I really lay out a good process for how this appointment should be done, and I want to hear your thoughts.
Section 28A. A. Upon receipt of notice of an applicable case from the request district attorney, a court order, or a sworn petition from a party or witness in the proceeding that has been screened for reasonable grounds to believe a conflict exists by a superior court judge, upon payment of a $50 filing fee and showing of standing, the Attorney General shall conduct a preliminary investigation to assess the existence of a conflict of interest. The preliminary investigation shall be limited to review of public records, interviews with involved parties, and access to non-privileged documents, provided, however, that the Attorney General shall not issue subpoenas, compel testimony, or empanel a grand jury during this phase. The preliminary investigation shall be completed within 60 days of receipt of notice, subject to a single 30-day extension for good cause shown to a superior court judge. If the Attorney General determines that no conflict exists, the Attorney General shall release public findings, redacted by order of a superior court judge to protect sensitive information. B. Upon a finding of probable conflict, the Attorney General shall recommend to the Governor the appointment of a special prosecutor and special investigative unit. The governor shall appoint such special prosecutor within 14 days of receipt of the recommendation, or upon court extension for good cause. C. The governor shall transmit to the General Court, within 30 days of appointment, a proposed yearly budget for the special prosecutor and unit, not to exceed 5% of the annual budget of the Rocust District Attorney's Office per applicable case, for approval by the House and Senate Committees on Ways and Means, provided, however, that the budget shall be deemed approved if not acted upon within 60 days, with interim funding from the governor's contingency appropriation under Section 6 of Chapter 29.
So does everyone understand? The governor can't, it's not every time the special prosecutor is going to get a budget of 5% of the DA's budget where that's recused. And it doesn't even come from the DA's budget. It comes from a separate appropriation. It's that the governor has to propose a budget to the general court, the legislature, the House Ways and Means, Senate Ways and Means, the Speaker and the Speaker of the House and the Senate President. And then, if they don't act on it within 60 days, it gets appropriated under the emergency funds from the governor's contingency appropriation under Section 6 of Chapter 29. But ideally, they act on it and create its own appropriation. So I can figure it out from the two words, but I can't figure out how that could shortcut your proposed bill. Oh, so a budget amendment, Bossy Texas Chicken Bella, what that means is when the legislature considers the budget, which I think is in the spring of 2026, there's all these amendments that go up from the representatives and the senators. A budget amendment can literally be a statutory change that isn't related to spending. So you can just throw on, it's called a rider, you can just throw this whole thing on, this whole bill, as a rider to the budget. So the budget is a must-pass. You get a rider attached to a must-pass bill, it becomes an omnibus piece of legislation that just looks like a budget, but is actually a budget plus like 50 bills. If you can get your bill, and you really need to do, they don't vote them, they withdraw a lot of them. The budgetary process in Massachusetts is very interesting. But anyway, the day that this happens, all the legislators, all the senators and reps throw up their amendments. A lot of them are going to get withdrawn. Some of them get voted on, 10% of them pass, and a lot of them are just laws. So when we talk about how to shortcut the formal process for legislative adaptation, which would require normally sponsorship at the beginning of the legislative session next January, not this January, but the next January after that, and then going to a committee, normally whatever committee, this would probably go to the committee on the Judiciary Committee. So you have to go there, you have to get it through the House Judiciary Committee, get it through the Senate. They need to ideally sponsor it as legislation that goes to the floor, and then you got to get it passed there. Ideally, you want like a 40-0 in the Senate and a 156-0 or 159-0 in the House. Anything more than 2/3 is normally going to be good. Then it's got to go over to the governor. The governor can veto parts of the bill, or which can be overridden, or the governor using a signing statement, or the governor can just ratify the whole thing. The governor's unlikely to veto something that has supermajority support because it can just be overridden with a simple procedural vote. So my point is that's how you shortcut the legislative adoption process using a budget amendment. It is formal lawmaking, but it only really happens via unanimous consent. You need to have a piece of legislation that is so wholeheartedly supported and robustly necessary and important that it gets passed through this unique procedural mechanism. So, anyway, that Bossy Texas Chick, I promise you Cosgrove's billing close to $400 an hour. I think I saw it the other day. Somebody posted some of the documents. He's probably billing $250 to $400 an hour, probably making a cool $250,000 off this, and I bet Mello made 6 figures, probably more. Lawyers bill a lot. The worst performing lawyers still bill 5 to 7 times minimum wage, maybe 10 times minimum wage. The middle tier lawyers bill like $200 to $300. The top tier lawyers bill $300, $400, $500, $600, $700 an hour. Okay, I'm not saying that everyone does that, but there are some lawyers that bill that much money. In order to compete, you have to pay these lawyers well. No lawyer makes less than a couple $100 per hour. That's not a thing. Some people do pro bono work, but even those people are normally doing it either because their other work pays so well or because their pro bono work is subsidized by a foundation that is actually paying them their hourly rate. They're just not billing the client. So yeah, no, there's no such thing as a cheap lawyer. Even the cheapest lawyers are well paid, and mostly, I mean, that doesn't mean they're good lawyers, but even the cheapest court-appointed lawyers are paid exceptionally well, because every lawyer is paid well. Yeah, every lawyer. That's why, like, I'm kind of looked at as like a class traitor among lawyers, because they're like, what are you doing, bro? Like, you just want to help people learn? Like, that there's no, like, what are you doing, man? Like, every one of us makes money. Like, that's how my colleagues think. Every one of them makes more in a day than I see in like a month or a year or whatever. And they think they're just baffled by someone who would not use that knowledge to do that. It's because every lawyer does that. They're all really well paid because it's this very high level apparatus they operate in, even at their weakest. If you get barred and you are a lawyer, you are at minimum going to make $200, $300 an hour. If you really, really know what you're doing and you're really good, like, I don't know, I'm not going to adjudicate my own skills, but like, I could bill, if I ever became a lawyer, just right out the gate, as I think what some of my colleagues who are starting to announce their offers, you look at some of these firms, what they pay their first year associates. This is at a private firm as a first year associate. Now you're working a lot, but they pay them like $180,000 to $240,000 a year. That's outrageous. Okay, and that's a private firm first-year associate who's just coming out of law school. Imagine what some of these lawyers who have been doing this for 40 years and are like former judges, very experienced, are billing. They are billing, you're not necessarily paying for their output in an hour. You are paying for 40 years worth of experience. That's why I spend a lot of time, like, even though I might not go into practicing law, I want to teach or whatever. I spend a lot of time watching trials. I have like 10,000 hours of invaluable courtroom experience, digitally, in person, whatever. That most lawyers don't have 10,000 hours of courtroom experience, but I do. And some lawyers that have that, you're paying them because, I mean, if I ever did this, which I don't really want to do, I want to teach, but if I ever helped a lawyer, what I'd want to work for is a lawyer who isn't billing for what they're outputting per hour, but what they know, what they learned, who they've talked to, the insights about case law. Maybe they were there when a key precedent developed on a point of law that's relevant in the case. That's who I want to work with. But that's very hard to find, first of all. And then the other thing is, if you do find a lawyer like that, which you need to win complex cases, they're going to bill you a lot of money because you are paying for 40 years of experience. So, yeah, well, someone's like, do you Bossy was wondering if you accompany the bill to the floor. No, you don't. You can go that day. You might be able to give testimony in a committee hearing. You can go into the gallery the day it's presented. Maybe you have a press conference, but you don't go to the floor. The sponsor, the person who walks you through it, like for the revenge porn bill, that was Senator Keenan. You walk, that person is the final person. That person speaks last before the bill is voted on and all of that. But yeah, it's a very complicated process. And then normally, once it goes to the governor, if the governor really likes it, they'll call the leadership in, the House Speaker, the Senate President, all the advocates who worked on it, the press. They'll bring you into this room, and you just sit there, and it's wild. Like, they talk about the bill, like all of them stand up there, like all 10 of them, the whole government. It's crazy when you go on that day. I've been on that day for other bills. They have to like literally security screen you because it's you. Like, so was in the press row for that. I was first row. It's you. No one, there's no like state police in front of you. They're in the room, but it's you, a foot of space, a podium, and then every member of the Massachusetts government, the governor, the assistant, what do they call it? Who's the Kim Driscoll, the lieutenant governor, the attorney. I don't know if the attorney general was there, but the Speaker of the House, the Senate, just the Senate president, just all of them. The person who sponsored the revenge porn bill, the people who were on the committee, the compromise committee that hashed it out. They're all there. And they just stand there and they talk about it. It's really an incredible moment. It's a very unique manifestation of the democratic process. I think it's very sacred, okay? By the way, did you know that in Massachusetts we worship a cod? Not kidding you. The Senate has a cod, and then the House has their own fish of some kind, the holy mackerel. No, I'm really not kidding you. We have a sacred cod and a holy mackerel. in the House of Representatives in Massachusetts, I'm not kidding you, we literally, it's a very sacred place that was centered on the fishing industry, so they decided they would worship a sacred cod and a holy mackerel. Personally, I think it's a little sacrilegious, and they were being ironic, but at the same time, it's hilarious. You go in there's a giant wooden cod, and you're like, what the hell, do you all worship at the altar of this thing? But yes, we should continue. Yes. Oh, so Bossy Texas Chick has so many good insights. I'm sorry for getting distracted, but Bossy Texas Chick was saying, I learned a lot about this watching the Fani Willis hearing. Yes. So in the Fani Willis situation, that Trump case has been referred to a committee, and there's a decision that's going to come down as to whether the case is going to be prosecuted now that she was removed from it. I had that in my mind when I was thinking about drafting the statute. So let's keep listening. I'm a little towel.
D. Prior to appointment, the prospective special prosecutor shall file with the governor a sworn disclosure of any material relationships within the past 5 years with parties, witnesses, victims, law enforcement, or political donors, or any family members thereof, in the applicable case, including professional, financial, or direct social connections. The disclosure shall be public, subject to redaction by superior court order. Failure to disclose a material relationship shall result in immediate removal by the governor, referral to the Board of Bar Overseers, and a civil penalty of not more than $10,000 enforceable in superior court and collected by the Attorney General, provided, however, that knowing non-disclosure shall constitute a misdemeanor punishable by a fine of not more than $5,000 or imprisonment for not more than 1 year, or both. The Special Investigative Unit shall be appointed concurrently with the Special Prosecutor and shall operate under the direction of the Special Prosecutor. E. The scope of the appointment, including jurisdiction and duration not exceeding 2 years, shall be approved at a public hearing before a single justice of the Superior Court within 30 days of appointment. The hearing shall be limited to disputes over scope and shall be open to the public unless sealed by court order for good cause. Attorneys for affected parties may appear and be heard, provided, however, that no interlocutory appeals shall lie, with finality subject to Supreme Judicial Court superintendence. F. The Special Prosecutor.
So what that means is that because you have a statutory right to interlocutory appeal, you can take it away, in my opinion, by statute, and only allow someone to appeal an order via the superintendency clause of the Supreme Judicial Court's power, and that's what I tried to construct there.
And unit may request additional time or resources from the governor for good cause, subject to Superior Court review within 14 days. G. The Special Prosecutor shall have all powers and duties of a district attorney under Chapters 12, 218, and 263, except the power to empanel a grand jury, which shall remain with the Superior Court.
Now, in case folks are wondering what this means that a special prosecutor, it's different if a case is already indicted when they come on after a recusal. Like, say you indict and then there's a recusal, that's different. But here I'm saying if you have a special prosecutor, first, to get a special prosecutor appointed, there's a bit of a process. But even then, that special prosecutor can't indict anyone. They don't have the power to impanel a grand jury. They have to bring charges of any kind, felony or misdemeanor, via a probable cause hearing in the Superior Court. All right, now you're going to find they're empowered, the special prosecutors, to operate in district court, superior court, SJC, appellate court, whatever. But I'm specifically saying they cannot use indictments. They cannot use grand juries. They have to, if they want to charge someone by felony, whether they want to whether they want to charge them with a felony or charge them with a misdemeanor, they have to do it via a public probable cause hearing in front of a judge. All right, so pay attention to that part.
Investigative unit shall have access to records and may conduct interviews, subject to court orders, provided, however, that the special prosecutor may issue subpoenas on behalf of the unit enforceable in Superior Court, subject to the standards of Chapter 233, Section 1. Pending grand jury proceedings shall transfer to the Superior Court for continuation under special prosecutor direction. H. The special prosecutor may bring charges only after a public probable cause hearing before a Superior Court judge, open to the public unless sealed for good cause. This requirement shall not apply to misdemeanor charges added after a felony indictment or bind over to Superior Court. I. The special prosecutor shall prosecute charges in the appropriate district or superior court and may appear before the Supreme Judicial Court on appeals. At the conclusion of the applicable case, The Special Prosecutor shall file a public report with the Attorney General and Governor, including findings, outcomes, and recommendations for systemic reforms, which shall be published online. Section 28b. A. The Special Investigative Unit shall maintain operational independence and shall not share non-public information with the request District Attorney's Office or involved law enforcement during the applicable case. At the conclusion of the appointment, the unit shall return all records to the Office of the Attorney General for archival under Public Records Law and shall disband unless reappointed for another applicable case. B. No member of the Special Investigative Unit shall provide services in an applicable case if such a member of the Special Investigative Unit has a material affiliation within the past 5 years with the request District Attorney's Office, parties, witnesses, or law enforcement involved, or any family members thereof, including prior employment or professional, financial, or direct social connections. C. Members of the Special Investigative Unit shall file disclosures mirroring those required of the Special Prosecutor under Section 28(d) with the Special Prosecutor prior to providing services. Violations shall result in disqualification by the Special Prosecutor, subject to Superior Court review, and referral to the Office of the Attorney General for enforcement. Section 28c. A. No victim/witness advocate shall provide services in an applicable case if the advocate has a material affiliation within the past 5 years with the request District Attorney's Office, parties, witnesses, or law enforcement involved, or any family members thereof, including prior employment or professional, financial, or direct social connections. B. Victim/witness advocates shall file disclosures mirroring those required of the Special Prosecutor under Section 28(d) with the Special Prosecutor prior to providing services. Violations shall result in disqualification by the Special Prosecutor, subject to Superior Court review, and referral to the Office of the Attorney General for enforcement. Section 28d. A. Sections 28 to 28g, inclusive, shall apply to any applicable case where a recusal or court order has been issued after the effective date, including ongoing cases post-indictment or post-arrest. B. Upon applicability, all records, evidence, and proceedings shall transfer to the Special Prosecutor within 30 days, subject to a Superior Court order extending for good cause related to case volume, with notice to victims as required under Chapter 258b. Failure to transfer shall constitute contempt. C. The Superior Court may stay proceedings for not more than 45 days upon motion by any party or sua sponte to prevent prejudice, with opportunity for victim input under Chapter 258b, and with tolling of speedy trial rights under Section 72 of Chapter 276. D. Upon assumption of the case, the Special Prosecutor may review prior actions and move to vacate orders or dismiss charges tainted by the conflict, including pre-transfer actions, upon a showing of prejudice by a preponderance of the evidence, provided, however, that post-indictment dismissals shall not bar refiling absent double jeopardy.
All right. Did everyone hear that? Upon assumption of the case, the Special Prosecutor may review prior actions and move to vacate orders or dismiss charges tainted by the conflict, including pre-transfer actions, upon a showing of prejudice by a preponderance of the evidence. So that includes like any plea bargaining or any other things that could have been tainted. So, but yes, let's continue listening.
E. The Special Prosecutor shall complete any required review and file motions under subsection D within 45 days of transfer. Section 28e. A. If the Attorney General determines a conflict under Section 28a that would impair the Attorney General's role in the preliminary investigation, the Attorney General shall notify the Governor and file a motion for recusal with the Supreme Judicial Court. The Court shall assign the matter to a single justice for resolution within 30 days. B. Upon recusal of the Attorney General, the Governor shall appoint an interim special investigator, such as a special master or attorney from an unaffiliated office, to conduct the preliminary investigation. C. Disclosures under Section 28(d) shall be filed with the Supreme Judicial Court upon recusal. Section 28f. A. If the Governor determines a conflict impairing the Governor's appointment role, the Governor shall self-recuse and notify the Attorney General, who shall file a motion with the Supreme Judicial Court only if not previously recused under Section 28e. The Court shall assign to a single justice for resolution within 30 days, who may appoint a special master to conduct any necessary review. b. Upon recusal of the governor, and following any Attorney General recusal under Section 28E, the Supreme Judicial Court shall assume the appointment role or recommend a special master to itself. c. Disclosures under Section 28A, d. shall be filed with the Supreme Judicial Court. d. Resolutions under Sections 28E and 28F shall be final, subject to expedited review only on direct appeal to the full Supreme Judicial Court within 14 days for abuse of discretion, defined as arbitrary or capricious action unsupported by substantial evidence. No further recusal motions shall be permitted absent an extraordinary petition to the full Supreme Judicial Court within 30 days based on newly discovered material facts. Section 28G. By the 31st of December of each year, the Attorney General shall submit to the General Court an aggregate report on all applicable cases under this chapter, including appointment statistics, outcomes, and recommendations for legislative adjustments, redacted as necessary to comply with Chapter 66. Section 2. This Act shall take effect on X. Section 3. If any of the sections or subsections of this Act shall be deemed unconstitutional, the remaining sections and subsections shall remain in full force and effect.
Hello. So, no, that revenge porn bill was a wide effort. It was a bipartisan bill. I think if you look at the press conferences from that day, and we can watch it, Bossy, Texas Chicken Ballot. Listen, I know people have been a big fan of Lindsay Cattani. Listen, I've never seen someone take social media by storm the way Lindsay Cattani has taken social media by storm. Now, listen, you're not following Lindsay Cattani on X and on Substack. Let me tell you right now, you're missing out, folks, all right? Lindsay Cattani's got things to say, all right? You follow that X account. I've never seen anyone get 250,000 views when they launched their X account like a month ago. She's incredible. So if you're not following Lindsay, let's join the Lindsay empowerment movement. But let's also watch this press conference because I'll tell you, it wasn't just Lindsay by any means that was responsible for the revenge porn bill being passed in Massachusetts. We were one of the last states, ladies and gentlemen. But I think Lindsay's press conference was absolutely one of the things that defined that day. Now, people said, oh, Lindsay just got up there and spoke. No. Who do you think set that press conference up? Hello, I'm a little towel. And it wasn't just for Lindsay, it was for the other people there that day, the other victims that wanted to speak. So Lindsay spoke last because that was her privilege, because I'm a little towel. And number two, this malicious rumor people spread that she just walked up and spoke. No, that was her speaking last because I was the one that made that press conference happen. So all those turtle riders out there just speaking nonsense, no. I have friends in the media. I know what I'm doing. I'm a little towel. All right, you know what I'm saying? So, but yes, I want to show you this press conference because Lindsay, I've never seen anything like it in my entire life. She got up there. Now, it was a little frustrating because Kate Peter joined that day, and Kate was going around at the State House bragging about how she had spread, people call her crusty whatever. She was bragging about that to the victims. And then she was talking about how she had spread revenge porn of Aidan or something. Kate Peter is a malicious, subversive force. She never, in hindsight, that never would have happened. She's never coming to the State House again, at least on my invitation. I don't want to be seen anywhere around her when there's lawmakers around. She's an embarrassment, in my opinion. All right, but let's take a look at, because Lindsay it was really about Lindsay that day. So Kate didn't even need to be there, and Kate only tried to sabotage everything because she's a weirdo, in my opinion. But anyway, let's watch the press conference. Come on now, I know I have it somewhere. State House press conference. I just watched it the other day. I think we watched it on stream. The reason why I want to bring it up is I thought it was a really good example of how someone just can empower themselves, and people were listening. I mean, the media listened. I'd say Lindsay probably got the most views that day by far. This, I will tell you, the Twitter search function is absolutely horrible. Absolutely horrible. Alright, I found it, little towels. I found it. Alright, we get to watch it now. Who's excited? It has 175,000 views. Now, that's not as many views as some of her tweets get. She gets 250,000 these days. Like, she's on another orbit. Like, she's her own, like those other people eat your heart out. Like, you are not Lindsay Catania, and you never will be. I'm talking about the people that, like, try to be her. But anyway, all right, or try to suppress her voice. Let's take a look at this. All right, this was Lindsay's first press conference, and I want to show you the numbers. All right, I just want to show you the raw numbers because it's almost unbelievable unless you see it. There you go, 175,000 views. All right, now let's listen to Lindsay. This was back in March of 2024, and let's take a listen. Obviously, a lot of people came together to work on that revenge porn bill, but I think the highlight of that day, at least in my memory, and probably for a lot of people, that bill will always be attached to Lindsay's name along with some of the other survivors because not only of this press conference, but just because of how strong you have to be to go through that. A shout out, of course, to Alex Haggerty, who worked on that bill, and so many others. How strong you have to be to go through that, put yourself out in public, and then tell lawmakers, hey, like, it's so important to get this done, and then to see it get done, incredible. Just incredible.
I'm here today to break my silence for the first time through public remarks. I'm sorry, I'm going to read through a pre-prepared statement. To begin, thank you, Madam Senate President, Mr. Speaker, members of the Senate, and members of the House. Your bold action to ban revenge porn and coercive control has given me the confidence to stand here today, and for that I am eternally grateful. So many of us over recent years have heard the phrase, revenge porn is legal in Massachusetts. It's been thrown around as if this is somehow an excuse for weaponizing the most intimate moments of a person's life as a form of emotional control and abuse. But today, lawmakers in both houses of this esteemed body have spoken with a unified voice and made clear that revenge porn is no longer legal in Massachusetts. And survivors like myself are the ones who can now hold our heads high in defiance of anyone who might seek to use revenge porn as a weapon. I want to stress, though, every day that passes before this bill is formally becomes law is for further agony for survivors. I encourage the Compromise Committee to get this legislation across the finish line as soon as possible. I heard it said once that whenever we stand against the flow of opinion on hotly contested issues, a woman does what she must, in spite of the personal consequences and dangers and pressures, for that is the basis of all human morality. If those words from a great human being who himself changed history still stand for anything, it is a profound principle that will be embodied when this legislation is quickly signed into law. Thank you for allowing me the opportunity to use my voice, and I just want to let you know I cannot take any questions at this time, but I just want to thank everyone for allowing me to speak today.
Can you just say your name again and spell it?
Lindsay Gattani, Lindsey, and Gattani is Gaetani.
Excellent job. Excellent job by Lindsay there. Now let us watch Georgia Kappelman's closing. So, I think that's a very good proposal, by the way, that special prosecutor bill. I'm not just tooting my own horn. I think it is a good proposal. I encourage you to support it. And B, little towels. It's not actually a bill yet, but, you know, give me a little bit. I know what I'm doing. I'm a little towel. All right, so it's a long haul, by the way. Nothing happens immediately unless I can really convince some powerful people that this has to happen immediately. Hold on. Speaking of happening immediately, Georgia, don't worry. I want you to start your closing. The Donna Adelson sentencing is just 1 hour and 15 minutes away, ladies and gentlemen. So, as we prepare, what better way to prepare than watching everyone's favorite prosecutor? You know her as Georgia. Her name is Georgia Kappelman. She is an assistant state's attorney down in Florida. All right, and this is what we are going to do. We're not going to get to watch the whole thing because Georgia, I think, with her rebuttal went for over 2 hours. But we're going to watch a decent amount of Georgia Kappelman's closing to prepare us for sentencing in the Donna Adelson trial. Now, as soon as sentencing commences at 3 p.m., we will turn right over to that. All right, tell friends. But we all love Georgia. Dan Markell got justice because primarily of Georgia and Sarah Duggan, Duggan, her co-counsel. Absolutely phenomenal decade plus almost of work from Sarah and from George Kaplan. So my name is Grant Smith Ellis. We're leading up to the 3 p.m. hour. If you're just tuning in, we're going to get a chance to watch Georgia, as I think is apropos today, ladies and gentlemen. Let me just put that. There we go. All right, here we go. We're going to watch the closing argument from the Donna Adelson trial from Georgia. And, so I don't know. I don't know why that happened, Colleen. It might be because you went from one device to the other. I don't know. I could be a YouTube setting. I don't know. Oh, but you know what we're going to do? I am going to reward you. If you stuck around, ladies and gentlemen, and watched through all of that, you are about to get gifted, potentially, towel memberships. Here we go. Here we go. Nope, I don't want to buy them. I don't want to buy them. Hold on. I think I have to do it on desktop. All right, everybody ready? Everybody ready to get your gift membership? So I click that. Nope. Hold on, I got to click this. All right. Here we go. I'm sending them now. We're about to have a membership parade. They have been announced. Congratulations. Bunny Towel and Dale. Hello, Troy and Chastity. Congratulations. And Carrie, Klepti, Fradaccio, and Squirrel. Congratulations. You have been gifted towel memberships. In particular, I am thrilled for Bunny and Dale and Chastity. And congratulations, you now have access to Super Towel emojis. You can go down in the chat there and look at all those emojis you have. You have Chloe the dog, you have the Stay Puft Marshmallow Man. You have a bunch of options. So congratulations to those who got their memberships. So you had to have been watching. I think that's how it assigns it. You had to actually have been watching at a certain point in the few minutes before it gives them out. So congratulations. I'll think about giving out another 5 as we get closer to 3 p.m. My name is Grant Smith Ellis. Georgia, take it away.
Morning. Well, this is Dan Markell. He's the victim in this case. A son, a brother, a colleague, a mentor, a professor, a friend, but most of all, a father, an Abba, a dad. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his time with those little boys in the wake of a bitter divorce from their mother. Defense called witnesses to come in here and give you an expert opinion that his divorce and the subsequent litigation was not contentious. Not contentious to whom? It was contentious to Dan Markell. It was contentious to Wendy Adelson. And it was contentious to this defendant. And then after telling you what a great guy Dan Markell was in opening statements, they called witnesses to tell you what a pain in the butt he was. And he was a pain in the butt to those people, those awful lawyers that can't even admit that divorces are emotionally charged. He was a pain in their butts. He was a pain in Wendy's butt, and he was a pain in Donna's butt. Why? Because this was his life we were talking about. Dan Markell was not a file on some lawyer's desk. He was a real person who cared passionately about every scrap of paper in that divorce file. He wasn't some bumbling idiot. He was a Harvard-educated law professor. And yeah, he was making it as difficult as possible for this defendant to get her non-negotiable, which just also happened to be Dan Markell's non-negotiable. those two little boys. You have learned about this conspiracy and how it has unraveled over the last 11 years since Dan Markel's death. The defendants in this case have all attempted to point fingers at each other. They have argued that the state's theory is right. It's right, you got it right, with everybody except for me. I didn't do it. Garcia's defense was that Charlie went directly to Rivera to arrange the hit on Dan Markel. Catherine Magbanua testified in her trial and said she had no knowledge of this murder. Charlie must have gone around her directly to Garcia. In Charlie's trial, he said Magbanua, Garcia, and Rivera all got together to kill Dan Markel without any direction from any Adelson family member. Each defendant characterized himself or herself as another victim in this case. A victim in this situation, a victim of their co-defendants, setting them up, or the appearance of evidence that seemed to implicate them but wasn't what it appeared to be. But despite their efforts to insulate themselves and to distance themselves from their co-conspirators, they made enough mistakes to get themselves caught and held accountable for their respective roles in this conspiracy. And today is Donna Adelson's turn. Despite their efforts to play victims, Dan Markel is still the only victim in this case. And the only thing he was guilty of was fighting like hell for those little boys. And he lost. He lost everything. This is what he looked like before. This defendant conspired to hire a hitman to have him killed, and this is what he looked like after. The evidence has shown that on July 18th, 2014, this brilliant, accomplished, beloved man was gunned down in cold blood in his own garage. And this horrific death ultimately set the police down two separate paths, following the two most promising leads that they had. The first lead was to chase down that Prius that, thank God, Mr. Geiger caught a glimpse of pulling out of the driveway that morning. And the second path was to ask, as we would with any murder investigation, who had a motive to want him dead? And within 1 hour of the shooting, well before Professor Markel had even been pronounced dead, this path was already pointing to the defendant when Wendy Adelson revealed to officers that her parents had more reason to dislike her ex than anyone else. And what offense had Mr. Markel committed against Donna Adelson and her family, refusing to let his children be taken away from him? Objecting to her telling his kids that he's stupid? The evidence has shown that Donna Adelson was all about psychological warfare, and when all else failed, she was willing to do whatever it took to accomplish her non-negotiable, to get a win. In order for you to render a verdict of guilty, the state must prove to you beyond a reasonable doubt that these crimes were committed and that this defendant is the person who committed the crimes, or in this case, one of the persons who committed the crimes. It is undisputed that these crimes were committed. This was a first-degree murder. No doubt about that. But who did it? The only issue left is identification, or what we call ID. The defense told you in openings, motive doesn't really matter. Don't pay attention to all the motive. Don't pay attention to all the emails. But motive can be compelling proof of who done it. Identification. And thus, critical to your determination of the defendant as one of the persons that committed this crime. Despite some of the testimony that you heard, it is clear that the divorce between Wendy and Dan was contentious. Except the person who cared most about Wendy's divorce and relocation specifically wasn't Wendy. It was her mother. Charlie Adelson solicited Catherine Magbanua to kill Dan Markel, but why? Who solicited Charlie? Because Charlie didn't care about the Adelson family getting a win against Dan Markel. He didn't care about relocation. He didn't care about Wendy's divorce. He cared about go-karts and jet skis and pretty girls. But he also cared about getting things done for the number one woman in his life, and that was his mother. She managed Charlie's life for him, and in return, he solved problems for her. That pattern is seen throughout this case. He talks to Wendy on the defendant's behalf to get her to pull the plug on the Tallahassee house, to date Dave and invite him to Mother's Day, to pursue a medical malpractice job, even though that's not even her area of the law, and on and on and on. She micromanaged Wendy's life. Charlie knows how to manage Wendy in a way that Donna can't, or knows how to talk to her in a way that Donna can't. And Wendy needs their help, right? Because according to them, she doesn't even have enough of a brain in her head to run her own life without their help. Donna decides what's best for everyone, and if she runs into any problems making that happen, Charlie is her go-to guy to get it done. He is the problem solver. And what was the biggest problem that Donna Adelson had in 2014? Dan Markell. Wendy filed her petition for divorce on September 10th of 2012, and the defendant was right in the middle of it. In the fall of 2012, the defendant told her son, Rob Adelson, that she had been in Tallahassee for several months, renting a new place for Wendy. She used her own maiden name to do that, to disguise the identity of who was renting it, arranging for movers, moving money around, and getting things set up for Wendy to leave Dan. Then Wendy calls Dan Markell and delivers the news that she's leaving him. How does she do it? She tells him she and the boys are moving out of the marital home, and the defendant gleefully, that was Rob's word, reported to Rob, her son, that she and Wendy strategically planned to deliver that news to Mr. Markell so that he would get this bomb dropped on him right as he's about to take the stage to deliver this lecture. According to Mr. Markell in one of his filings, quote, while the husband was away on a short business trip, the wife left the husband in the marital home, taking with her the children's furniture, clothing, toys, and whatever assets, both marital and non-marital, she desired. The evidence has shown that from the start, this defendant was very involved in managing Wendy's divorce. In October of 2012, defendant writes an email entitled, Things to Discuss at Your Mediation to Make Sure You Have in Writing for a Settlement, in which she refers to Wendy as a hostage and a prisoner in Tallahassee. That's what she believed. The email also includes the suggestion that Wendy pursue a restraining order against Dan Markell, that Wendy should go for 100% full custody of those two kids and relocation, and the threat of this conversion to Christianity. Quote, if he leaves you in Tallahassee, the children will not be attending Hebrew day school. That's not a threat, just a warning. A warning that her friend, Ms. Cunningham, on the stand dismissed. Oh, that was just a foolish thing to say, right? But the characterization of these threats as, just something that was a one-off heat of passion thing has been completely destroyed by the evidence in this case, because she repeats it. She plans it with a lot of specificity. Wendy even admitted that her mom was serious about planning a baptism for these kids to change their religion as a ruse to try to strong-arm Dan Markell into giving up those kids. This is an example of the defendant operating with the emotional subterfuge as described by her daughter, Wendy Adelson. Also remember how her son, Rob, described her. She has rigid and fixed ideas of what she wants. And as long as you comply, things are fine. But when you don't comply, things are not fine. Wendy admitted that if Dan had relented and moved to South Florida, or at least allowed her to move there, they might have co-parented happily ever after. But Dan did not comply, so things were definitely not fine. The defendant ends this email with, quote, we will help you in any way possible for you to come here. In October, this defendant drafted language for Wendy's petition to relocate, including allegations that Wendy had been upset about having to live in Tallahassee since 2005, and a mention of putting the boys in a Christian school and on a non-kosher diet. Again, that's not a threat, just a reality. And the suggestion that the boys live in South Florida with Wendy and Dan just fly back and forth to see his kids. He can just come see them every other weekend by airplane. Doesn't that sound like an amicable, equal time sharing that the lawyers for the defense described was going on here? Wendy's lawyer says she had no knowledge of Wendy's mom being involved in her divorce, but the evidence shows she absolutely was. Wendy sends the proposed petition for relocation from her lawyer to the defendant with a note that says, here it is, let's edit. And the defendant responds the next day with detailed feedback, including an argument that Dan Markell is incapable of taking care of his own children and that Wendy should seek 100% custody. Arguments which Wendy forwarded to her lawyer as her own. And upon receiving the lawyer's answer, she sends the lawyer's answer back to the defendant. That's in evidence. Defendant's thoughts about Wendy's earning potential and her work environment in Tallahassee. Arguments about she'd be better off with this other job that's higher paying in Miami. And defendant says she's been living in Tallahassee, that she, the defendant, has been living in Tallahassee since the petition was filed to help Wendy with the boys. In January of 2013, the defendant advises Wendy on her amended petition to relocate. And this is where the argument is raised about the job as a major bargaining chip in the divorce. The defendant writes here that Dan needs to know that there's no way in hell Wendy is going to stay at FSU. On January 14th, Wendy files an amended petition with request to relocate, which you can read and see. The petition contains many of the defendant's arguments. She couches this relocation in terms of not only important, but like a matter of life and death. Look at these quotes. It will create a major negative change in our lives. It will ruin your entire life. The rest of all our lives. Mine, Dad's, and even Charlie's will be affected by how well she can perform and act before July 31st to try to get this relocation thing turned around. Donna has even started pre-screening men for Wendy to date in the Miami area. In February, Dan files his response to Wendy's motion to relocate, alleging Wendy took his stuff when she left. The sole reason for relocation is to be close to her mother and family in South Florida, and that contrary to what Wendy put in her pleading, he was not seeking to leave FSU. He wasn't trying to move. Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense experts ever seen, but pretty nasty. Dan Markell requests sole decision-making authority for these kids regarding education, medical, and religious matters for you. In the pleadings, and Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense experts ever seen, but pretty nasty.
Not sure why that would be.
Dan Markell requests sole decision-making authority for these kids regarding education, medical, and religious matters. The defense lawyer witnesses said, oh, that was never going to work. Maybe that's true. But these were concerns that Dan Markell took seriously. There's tons of September 10th of 2012, and the defendant was right in the middle of it. In the fall of 2012, the defendant told her son, Rob Adelson, that she had been in Tallahassee for several months, renting a new place for Wendy. She used her own maiden name to do that, to disguise the identity of who was renting it, arranging for movers, moving money around, and getting things set up for Wendy to leave Dan. Then Wendy calls Dan Markell and delivers the news that she's leaving him. How does she do it? She tells him she and the boys are moving out of the marital home, and the defendant gleefully, that was Rob's word, reported to Rob her son, that she and Wendy strategically planned to deliver that news to Mr. Markel so that he would get this bomb dropped on him right as he's about to take the stage to deliver this lecture. According to Mr. Markel in one of his filings, quote, while the husband was away on a short business trip, the wife left the husband in the marital home, taking with her the children's furniture, clothing, toys, and whatever assets, both marital and non-marital, she desired. The evidence has shown that from the start, this defendant was very involved in managing Wendy's divorce. In October of 2012, defendant writes an email entitled, "Things to discuss at your mediation to make sure you have in writing for a settlement," in which she refers to Wendy as a hostage and a prisoner in Tallahassee. That's what she believed. The email also includes the suggestion that Wendy pursue a restraining order against Dan Markel, that Wendy should go for 100% full custody of those two kids and relocation, and the threat of this conversion to Christianity. Quote, if he leaves you in Tallahassee, the children will not be attending Hebrew day school. That's not a threat, just a warning. A warning that her friend, Miss Cunningham, on the stand dismissed. Oh, that was just a foolish thing to say, right? But the characterization of these threats as, just something that was a one-off heat of passion thing has been completely destroyed by the evidence in this case, because she repeats it. She plans it with a lot of specificity. Wendy even admitted that her mom was serious about planning a baptism for these kids to change their religion as a ruse to try to strong-arm Dan Markel into giving up those kids. This is an example of the defendant operating with the emotional subterfuge as described by her daughter, Wendy Adelson. Also remember how her son, Rob, described her. She has rigid and fixed ideas of what she wants. And as long as you comply, things are fine. But when you don't comply, things are not fine. Wendy even admitted that if Dan had relented and moved to South Florida, or at least allowed her to move there, they might have co-parented happily ever after. But Dan did not comply, so things were definitely not fine. The defendant ends this email with, quote, we will help you in any way possible for you to come here. In October, this defendant drafted language for Wendy's petition to relocate, including allegations that Wendy had been upset about having to live in Tallahassee since 2005, and a mention of putting the boys in a Christian school and on a non-kosher diet. Again, that's not a threat, just a reality. And the suggestion that the boys live in South Florida with Wendy and Dan just fly back and forth to see his kids. He can just come see them every other weekend by airplane. Doesn't that sound like an amicable, equal time sharing that the lawyers for the defense described was going on here? Wendy's lawyer says she had no knowledge of Wendy's mom being involved in her divorce, but the evidence shows she absolutely was. Wendy sends the proposed petition for relocation from her lawyer to the defendant with a note that says, here it is, let's edit. And the defendant responds the next day with detailed feedback, including an argument that Dan Markel is incapable of taking care of his own children and that Wendy should seek 100% custody. Arguments which Wendy forwarded to her lawyer as her own. And upon receiving the lawyer's answer, she sends the lawyer's answer back to the defendant. That's in evidence. Defendant's thoughts about Wendy's earning potential and her work environment in Tallahassee. Arguments about she'd be better off with this other job that's higher paying in Miami. And defendant says she's been living in Tallahassee, that she, the defendant, has been living in Tallahassee since the petition was filed to help Wendy with the boys. In January of 2013, the defendant advises Wendy on her amended petition to relocate. And this is where the argument is raised about the job as a major bargaining chip in the divorce. The defendant writes here that Dan needs to know that there's no way in hell Wendy is going to stay at FSU. On January 14th, Wendy files an amended petition with request to relocate, which you can read and see The petition contains many of the defendant's arguments. She couches this relocation in terms of not only important, but like a matter of life and death. Look at these quotes. It will create a major negative change in our lives. It will ruin your entire life. The rest of all our lives, mine, Dad's, and even Charlie's, will be affected by how well she can perform and act before July 31st to try to get this relocation thing turned around. Donna has even started pre-screening men for Wendy to date in the Miami area. In February, Dan files his response to Wendy's motion to relocate, alleging Wendy took his stuff when she left. The sole reason for relocation is to be close to her mother and family in South Florida, and that contrary to what Wendy put in her pleading, he was not seeking to leave FSU. He wasn't trying to move. Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense experts ever seen, but pretty nasty. Dan Markel requests sole decision-making authority for these kids regarding education, medical, and religious matters. The defense lawyer witnesses said, oh, that was never going to work. Maybe that's true. But these were concerns that Dan Markel took seriously. There's tons of discussions in evidence in these binders before you, in the pleadings and in the emails, about Dan Markel's desire to raise these boys in accordance with his faith, and his concerns that his wishes were going to go right out the window as soon as the boys went over to be with Wendy or her mother. And defendant took this matter seriously too. She made it crystal clear in these emails that she had no respect for these boys' fathers' wishes for them regarding religious practices. In this email, defendant says she's sitting at Wendy's kitchen table working on Wendy's response to the filing we just talked about that Dan Markel made. So much for her having no involvement in her daughter's divorce. She says in this email to a friend, all Wendy wants out of this is to relocate to South Florida, where she has us and Charlie. Danny is making it very difficult. On March 5th, 2013, defendant sends a long email in response to every paragraph of Dan Markel's arguments against relocation, including that Dan's religious practices are fanatical and dangerous to the boys, and that Dan Markel is psychologically unfit to have custody of his children. It's not sounding very amicable, is it? In opening statements, the defendant's attorney acknowledged that Dan Markel was an intelligent, accomplished professor and a dedicated father, and the state could not agree more. But the evidence has shown that her client didn't agree with that. Donna Adelson repeatedly paints Dan Markel as a self-important idiot who's not fit to care for his own children. On March 6, 2013, Dan Markel sends Wendy an email threatening to take her to court over her failure to cooperate with the Skype thing. That comes up repeatedly. Here he says, you've made zero efforts to facilitate that when you or your mother could have easily done so. I don't want conflict or tension. I desperately want peace and joy. Please let that happen, but do not mistake my politeness or desire for cooperation as a lack of firmness. I will not tolerate failures on your part to keep our agreements. They did have a Skype agreement, and she was violating it, and he was furious about it. This email was forwarded by Wendy to this defendant, so she knows about all this stuff. Dan Markel sent Wendy an email in December, which was pretty personal, and in which he is kind of a mea culpa. He apologizes for things that went wrong in the marriage and takes some accountability for what he views as his mistakes in the marriage. And Wendy forwards this email to her mother. Then Donna responds to this personal email and goes through Dan Markel's writings paragraph by paragraph, suggesting how Wendy can manipulate his words against him. Oh, look, he's admitting this here. This will help you in the divorce. And she does it in Wendy's voice. It's weird. Look at it. So although sometimes Wendy seems to be complaining about her mom overstepping, she's trampling my autonomy, it's like she's also inviting her mother into her business and wants her help, but also don't trample my autonomy. In fact, Wendy thanked her mom for the thoughts that she gave on this letter Dan Markel wrote. She also wrote that she never would have left Dan Markel without her mom's support. In May of 2013, the defendant refers to one of Dan Markel's responses as a, quote, 23-page rant. Then she doubles down on relocation as the most important and non-negotiable part of Wendy's divorce. I mean, how many times does she have to tell y'all it's important, but somehow the defense is still, it wasn't important, or it was over. It didn't matter. She notes here that Dan Markel threatened Wendy with federal kidnapping charges. He threatened her daughter with federal kidnapping charges for taking those kids without telling him where she was going when she left. The defendant signs off, "I'm too angry to write anymore." And the evidence has shown that this nice, normal, sweet little grandma certainly was angry. To support the argument that Wendy should be able to relocate because Dan was always traveling on work trips, the defendant sends Wendy this email. And it contains every date, like the date ranges that Dan Markel has been out of town traveling for work since the birth of their first child. That's 4 years. She is able to go back and send to Wendy, he was out of town this date to this date, this date to this date. It's a little shocking that she recorded that information, but we know she is a very detailed person. She keeps these extremely detailed day planners. But Dan Markel's travel schedule is of particular interest, in fact, in light of the fact that the hitmen knew that Dan Markel had to be killed on July 18th because he was going out of town the next day. The question is, how'd they get that information? Who had that information? Then the next day, Dan Markel files a memo of law asking for the attorney's fees and saying that, quote, if costs are not awarded, then the wife and her affluent parents who are bankrolling the wife's litigation so they can enjoy closer access to the grandchildren will persist in vexatious and groundless litigation. Dan Markel knew that Wendy's parents and their considerable resources were a big part of why this divorce litigation was dragging on. They thought he was filing frivolous stuff to drag out the divorce and the proceedings, and he thought the same thing about them. On June 21st, the court issued the order denying relocation. When Wendy was on the stand, the defense made a big deal out of, oh, you didn't tell mom it was final, did you? You stipulated to it, didn't you? Which we later learned was because the judge had already ruled at sidebar that it wasn't going to happen. But basically, you kept your poor mom in the dark and she thought this was still something that was viable and you didn't tell her it wasn't. But on redirect, it was proven that that was not true. Defendant did know that the order was final, and she expressed this in an email to her friends. Poor mom wasn't kept in the dark on anything in this family. In fact, the defendant recognized perfectly well that this order meant she wasn't going to get relocation through the courts. She wasn't going to get what she wanted through the legal system, but that wasn't the only way to skin a cat, was it? She wasn't deterred by a loss in court. Instead, she started looking into other options to get a win for the Adelson family. There was testimony offered that everyone knew that there was a slim chance of Wendy winning relocation. Maybe everyone knew that on the lawyer's side, but the defendant didn't know that. She was not happy about this loss in court. Here she laments, unfortunately, after paying a lawyer $600 an hour for 10 months case preparation, the judge listened to Wendy for 1 hour and made up her mind. Outrageous. So at the moment, we will not be allowed to relocate. Note the phrase, at the moment. Jibbers had not beaten the Adelson family yet. Defendant concludes this email, anyway, if I sound angry, it's because I am. We're all very upset and cannot believe the outcome. She couldn't believe relocation was denied. When Wendy expresses defeat over the court's order, the defendant isn't having it. She encourages Wendy to never, never, never give up, to take control, to not let Jibbers think he's won anything by having you remain in Tallahassee, and to show this fucker what will make him absolutely miserable. How amicable. Then defendant solicits Wendy to put on the performance of her life because Jibbers hadn't beaten the Adelson family yet. And this is where defendant reveals her plan of action, including having her Jewish grandsons baptized and offering $1 million to Dan Markel to facilitate this relocation. Control is a theme that's featured prominently throughout this email and throughout this case. There is evidence that the defendant controlled Wendy, she controlled Harvey, and she controlled Charlie, but she could not control Dan Markel. He wasn't going to give her a win. As long as you went along with her rigid, fixed ideas, things were fine. But if you didn't, things were not fine. Defendant continues to react to relocation being denied and Wendy's inclination to give up on the matter, including, everyone has a price. Now is the time to start. You said this divorce is not about winning and losing, and it's not a competition. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family, teaching in Tallahassee. Life is tough. If you don't stand up and take a chance, you don't stand a chance. Please, Wendy, do your part and stand up to him. Make an effort to do this so that our group offer will stand a better chance of being accepted. Don't let this temporary move to Tallahassee ruin your entire life. Fight for yourself, Wendy. We'll be there to help you. Just don't tell us that what you need to do is move forward with a sense of peace. Can't have that, can we? That's giving up. Giving up on relocation was not an option for Donna Adelson. Neither was losing. Throughout the trial, the defense tried to distance themselves from these emails. One of the ways they did that was by trying to put them off on Harvey. They pointed out, hey, this is a joint email account. One of these is signed Mom and Dad. And there's a few that are signed Mom and Dad, but it's clear that the defendant is the author of these emails and that she's the one driving the bus on this relocation effort. And during the presentation, we highlight all the dad and I language, all the indications in there that Donna is the author as opposed to Harvey being the author. According to her own daughter, Wendy, she's the dominant force in that household. And according to her son, Rob, she is a controlling person as opposed to the more passive, go with the flow type of personality that the dad, Harvey, has. In opening, the defense attorney told you that this defendant was a normal person, and you don't have to decide she's not a normal person. You're the judge of the facts, right? Was a crime committed? Is this the person that committed the crime? But in this email, she suggests that dressing her Jewish grandchildren up in Hitler youth uniforms would be acceptable. That would accomplish her goals. The ends justify the means for her, people. That is illustrated here, and it sums up this entire case. The defendant wanted this done because that was the only way left to get a win. If he had submitted, if he'd let her take those kids, he'd be alive. If he'd moved to South Florida himself, he'd be alive. But he would not submit. She could not get that win. He was a huge problem, and she made it Charlie's problem. To Charlie, who liked the idea of being a tough guy, who had connections to people on the wrong side of the tracks, the price of Dan Markel's life was worth the reward of pleasing his mother and easing her diarrhea and getting her to finally shut up about Wendy's divorce. In the mind of this defendant, all their lives depended on the success of this relocation effort. She tells you as much herself in these emails. Listen to her. And as such, any and all means were justified. Because not everything one has to do in life is comfortable or easy. Sometimes it's ridiculously hard. This is what passes for normal in this family. I said the defendant made Wendy's divorce Charlie's problem, and the evidence shows that the defendant did keep Charlie in the loop every step of the way. Here's a July 10th email that states, just to catch you up on what's happening with Wendy, and discusses who should be involved in the bribe that the family wants to offer to Dan Markel. On July 19th, the defendant requests and Wendy sends her copies of the motions, responses, orders, and transcripts from her divorce so far. That same day, Dan Markel makes a settlement offer that this defendant encourages Wendy to reject, saying the answer is no to all of this. Please, Wendy, we've been with you from day one. Do not accept or sign anything without the two of us reviewing and discussing all of this with you. Screwing him financially is what will aggravate him. But ultimately, a settlement is reached. You all have heard about this date, July 31st, 2013. But contrary to what the defense has told you, the fighting did continue. On October 12th of 2013, 3 months after the divorce was final, the defendant forwards an email to Charlie Adelson, which Dan Markel had sent Wendy. And the defendant adds the note, "This is what this fucker is sending your sister on a regular basis. He is absolutely crazy. Impossible." Does it sound like everything was over? This was the amicable divorce over? Not contentious at all, right? This is fall of 2013, the same time frame in which Wendy starts dating Jeff Lacoste and Charlie starts dating Catherine Magbanawa. On October 13, 2013, the defendant texts Charlie Adelson, quote, "Horrible evening for your sister." The pattern of this defendant getting worked up about Wendy's divorce and then forwarding it on to Charlie is seen over and over again. Which brings us to Halloween 2013. Several important events in the case occur on Halloween 2013. One, Wendy officially takes Dan Markel back to court, filing her motion to enforce the marital settlement agreement. So she's alleging he violated it, and she's asking to hold him in contempt of court, alleging that he's not paid the agreed upon fees that he was supposed to pay by a certain deadline. Wendy backs out of the contract that she had signed to buy a house in Tallahassee on Halloween 2013. Charlie later brags to the defendant that he talked Wendy out of buying the house, and the defendant calls him a miracle worker for having convinced Wendy not to buy the house in Tallahassee. Also, Charlie meets up with Catherine Magbanawa on Lincoln Road on Halloween 2013, the same day Wendy pulled the plug on the house, and broaches the subject with her for the first time of, "Hey, do you know anybody that I could hire to harm someone?" And she did. Charlie sends this picture of himself and Catherine Magbanawa together to Wendy that night, October 31st, 2013. First night, he solicited Catherine Magbanawa to be a part of a murder, or a part of what would become a murder. Mid-November, Jeff Lacoste meets the defendant for the first time. Remember Jeff? He was Wendy's boyfriend that testified. He said he would meet her 6 to 7 other times in addition to that first time during the course of his relationship with Wendy. Sometimes just in passing, picking Wendy up for a date. Other times more substantially, including taking the boys to the circus. And that becomes maybe important later. Meanwhile, the fighting continues into December. We're in December of 2013 by now. On December 16th, Dan Markel emails Wendy and the parenting coordinator that was assigned to help them try to navigate these issues about the defendant, Donna Adelson, disparaging him to his kids. In this email, he introduces what he calls a major issue. The headline on this concern is not buried, guys. Like he says, I'm introducing a major issue. He very plainly gives a preview of the grandma motion, which will ultimately be filed in March of the next year. And here he says that on November 8th, one of the boys announced at a Markel family dinner that grandma, referring to this defendant, says you're stupid. Grandma says you're stupid. Then the following Monday, on November 11th, when Dan Markel was buckling the boys in at the park, they both tell him that Grandma says you're stupid. When asked why, they say because you're trying to take her sunshines away from her. When asked who are her sunshines, the boys answer they are her sunshines. Then again on November 30th, while playing with the older child, that child repeated the statements to Dan Markel, Grandma says you're stupid. And again, when asked why, the child repeated that the defendant said that Dan Markel was stupid because he was trying to take Grandma's sunshines away from her. Markel implores Wendy to address the situation, as he would like to avoid a hearing in which his kids are going to be primary witnesses against their grandmother. He assures her that he will, though, if necessary, seek judicial relief that prevents contact between the children and their grandmother. This lawyer that testified said, oh, that wasn't going to work. Well, he didn't think so. Oh, well, that's no big deal. I've seen much worse than that in my career. Dan Markel hadn't seen much worse than that. Dan Markel had a big problem with Grandma saying he was stupid, and he wanted to take it up and address it with the judge if necessary. Dan Markel emphasizes that this is a matter he takes very seriously and says that the defendant's actions could lead to the termination of Wendy's parental rights. Is that true or not? Doesn't matter. He thought it was true, he threatened it. And those are fighting words. Going to terminate your parental rights? Wendy forwards the email to the defendant the next day, December 17th. And what's the response? Wow. That's a response we see from the defendant quite a bit. She's usually more verbose, that's true. But why is the defense working so hard to say that their client didn't see this email and didn't know about these allegations? I mean, isn't it clear that Wendy is sharing all the issues relating to her divorce with her mother? Wendy communicated with her mother on all these filings, and this one pertained directly to her mother. Of course they discussed it. Are you really to conclude that nobody was fighting anymore prior to Dan Markel's murder when the evidence leads you to conclude the exact opposite? This was a pressure cooker, and it was being turned up hotter and hotter with each passing day. Not only is this a situation that's escalating between the actual parties to the litigation, but now the defendant has moved from working behind the scenes, helping Wendy with the divorce, to actually being the subject of the pleadings that are before the court. There was supposed to be a hearing on that issue. One thing Dan Markel wrote in this email is, quote, I fear that the children's best interests are not being pursued so much as what Grandma wants. If he only knew how legitimate that fear really was. Those weren't just some ugly, foul words thrown around in the heat of the moment, folks. They continued well past the finalization of the divorce. Here on January 10th, 2014, so now we're into the year where Dan Markel is killed. 6 months after the divorce is final, defendant says of Dan Markel, wow, is he on drugs? Is he also going to pay $70K plus the legal fees and interest that bastard owes you? So the bad blood is going strong here 6 months before the murder, and the divorce wasn't really final anyway, in the sense that we're continuing to have pleadings get filed back and forth. In February of 2014, Dan Markel emails Wendy threatening to file motions exposing her for what he said was hiding assets, $200,000 worth of assets from the court, and giving false testimony under oath. And also to accuse her attorney of misconduct. Her lawyer witnesses say none of that's a big deal, none of that was going to be successful, but he thought it was going to be successful. To him, it's a lot of money. To him, it's a big deal. The next day, on February 15th, 2014, we see a text from the defendant to Charlie. Wendy's totally stressed out. Yesterday was a rough one. She will probably have to go through another depot. Outrageous. Rob Adelson testified that his mother told him they were, quote, depoting Wendy to death. But then their expert witness got up there and said Wendy was never deposed. I guess they didn't provide her with that information or any of these emails or text messages post July 31st, because this thing was not over on July 31st. In this text, defendant accuses Dan Markel of stalking Wendy, and Charlie agrees. The defendant tells Charlie to keep the conversation with Wendy light and don't bring up the divorce drama, which kind of implies there was divorce drama going on. There's a sense in this email and elsewhere in the evidence that defendant and Charlie have to tiptoe around Wendy, like she's this damsel in distress that needs the two of them to step in and help her handle her business. On February 17th, 2024, defendant again reports to Charlie how Wendy's hearing went and talks about how there are plans to seek to have Dan Markel forced to submit to psychological testing. Here, defendant is 7 months after the divorce and just 5 months before the murder, responding to Dan Markel's filing a request to produce, and she says it's time to give it to him. Let's aggravate him the way he's trying to aggravate you. And what can your attorney do to be proactive to give him some grief? Can't you meet with her and work out a plan of attack? Something has to be done with this asshole. This is 5 months before the murder. Here, defendant texts Charlie about Wendy yet again. If you speak to Wendy today, tread lightly. Don't ask questions about the depot, her lawyer, etc. Tough time, and she's really stressed out. The asshole showed up at soccer yesterday, and she goes into a story about, he showed up at soccer and they got into it. And then she ends with such a fucker. Super amicable. Then we have this text on March 4th, switching gears. This is about the birthday gift. Defendant texts Charlie that she's going to call him from the bathroom in Gainesville where she can have some privacy. Please pick up because I will have very limited alone time today. Erase this text after you read it. Then the defendant says we'll speak privately about Dad's birthday gift. So erase after reading. You might think, well, maybe she was just trying to keep the birthday gift a surprise, but why does Charlie need to erase it? Harvey's not with Charlie, Harvey's with Donna. And according to Rob, there were no birthday gifts for Harvey unless the murder was supposed to be the birthday gift. Plus, in the text, Donna wants Charlie to delete after reading the text that doesn't mention the birthday. She doesn't say anything about deleting the one that does mention the birthday. Rob Adelson was present at the birthday party, which did take place between the two trips that the hitmen took to Tallahassee. And there were no birthday gifts, according to him. The defense suggested that the friends coming to the party was part of the surprise, but then they all suggest that Harvey sent the Evite, so I don't think they gave it both ways. You can't send the invitations and be surprised by the friends. The next week, Jeff Lacoste, Wendy Adelson, Catherine Magbano, and Charlie Adelson all go out to dinner. That's the first meeting between Wendy and Jeff and Catherine Magbano. At dinner, Magbano mentions her ex having several run-ins with law enforcement. That stuck out to Mr. Lacoste. After dinner in the hot tub, Charlie bragged about having connections to people on the wrong side of the tracks. Notable in the time frame, March 21st, 2014, the defendant signs a lease on a condo in South Beach, a condo where Wendy, after Dan's killed, would move in with her kids. They say, oh, that was a weekend place, so it's pretty convenient timing. You just happen to get this other house and have it set up for Wendy to move into after her ex-husband's murdered, and she's able to relocate. 3/26/14, this is when Dan Markel officially files the grandma motion, which takes aim at the defendant raising more allegations about failure to comply with the Skype thing, Wendy leaving the boys with her parents rather than giving him the right of first refusal. And he says by flouting the right of first refusal, the former wife creates conditions for Mr. Markel to be disparaged in the presence of the children by their maternal grandmother. Dan Markel then alleges all the same allegations about the defendant disparaging him to the kids that in that previous email in December. Contrary to what the defense said in court, in his prayer for relief, the remedy Markel was seeking was to have the court order this defendant to have no contact with those boys unless she was supervised, because he didn't want her disparaging him to the boys, and because it was a violation of the right of first refusal, in his opinion, for Wendy to leave the boys all the time to her mom and not give him a chance to have them if Wendy wasn't going to keep them. How do you think Donna took this information? She refers to those kids as hers. She was the one sacrificing her time at the office to be up here in Tallahassee doing for those boys. She had invested so much of her own time in this fight against Dan Markel to try to get a win for the family. And after all that investment in those kids and all the money spent on the attorneys and all that time spent at the kitchen table working on those divorce filings, Donna Adelson was losing. The boys and Wendy were stuck in Tallahassee. Wendy wasn't working at the law firm in South Florida, raking in a bunch of money and dating some new guy that she pre-screened for her. And Grandma's Sunshines weren't in South Florida. That's where they belonged. That's what was best for them. They had lost in court. Wendy wouldn't comply with Donna's plan of action, and Dan Markel apparently wouldn't take a bribe or be strong-armed to allow his kids to come to South Florida. But as it turns out, Jibbers still had not beaten the Adelson family, because there was still another option, the option of hiring the hitman. Charlie joked about hiring a hitman, but he had also been actively pursuing that option at least since Halloween of 2013. Over the last several months, Charlie had several conversations with Catherine Magbanoa about this job, which started as a request to harm and then eventually revealed itself as a murder for hire. Recall that Magbanoa said that often when she and Charlie would discuss the murder and the pressing need to get it done, he would emphasize to her that the toll that Wendy's situation was taking on his parents emotionally and physically, as they were stressed to the point of being physically ill. So he would often tell her that's the motive. That's why we need to get this done. It's like stressing out my mom. On May 16th, 2014, 2 months before the murder, Wendy was added as a resident to that condo in South Florida. On May 30th, 2014, Donna sends Charlie the text, quote, "Horrible morning with Danny. Tough conversation with her." It was sent less than 2 weeks before the murder. The drama is continuing. Everyone's still fighting. It's contentious. Prior to the June trip, Charlie had prepared an envelope containing the murder instructions. He told Catherine Magbanoa that he used gloves when handling the paperwork inside, that he printed it not on any printer that can be connected to him, and that she was not to touch the contents of what was inside. She was to deliver the envelope to Sigfredo Garcia. She followed these instructions. In early June, she came to Charlie asking for travel expenses for the hitman. She got a couple $100 to give them to rent a car to come up here. They came. Well, let's back up just a little bit. They rented the car June 2nd, 2014. Magbanoa drops Garcia off at the rental car place, and then Magbanoa calls Charlie on the way home from the rental car place. And you saw the evidence of this in Sergeant Corbett's presentation. Charlie immediately calls Donna on the landline after hanging up with Magbanoa. How do we know that he talked to his mother and not his dad, since it was the landline? Well, because a few minutes after that call, he talks to Dad on his cell. So talk to Dad on the landline, and then a few minutes later talk to him on the cell. Garcia and Rivera traveled to Tallahassee. This is June 4th, 2014. Rivera notes that Garcia is in possession of a piece of paper. The paper has a photo on it and some information. This information allowed them to locate and follow Dan Markel's vehicle, a black Honda Accord with the tag number 534YBM. Information that the defendant had written in her 2014 planner. Wendy and Jeff Lacoste have their coffee date, at which she cancels their planned trip to California on July 11th through the 17th. She offers no real explanation for why she's canceling, except to say that she's real worried about being able to pick up the boys on the 18th. The 18th, of course, ends up being the day that Dan Markel is killed. Later that night, Jeff Lacoste goes to Wendy's, and she's a nervous wreck. She won't tell him what's wrong, but her stomach's upset, and he goes and gets her Pepto-Bismol. The killers are in town when that happens. The hitmen spend a day and a half following Dan in Tallahassee. Here they are near the park there by his residence. They scope out his residence, and although Rivera had already purchased the murder weapon, a revolver that he got on the streets for the express purpose of killing Dan Markel, they lost him, or he was with the kids, or for whatever reason they did not get the job completed on the June trip. After the hitmen failed to get the job done, Charlie tells Donna on June 7th of 2015 that he's still working on Dad's birthday present, and she says, "I know you'll come through." Sometime around June 11th, Jeff Lacoste went over to Wendy's residence and observed her living room TV to have some impact damage. This was the same TV that Charlie got Wendy as a divorce present because it was cheaper than hiring a hitman. The location and damage to the set did not appear consistent with something the kids could have caused, at least to Jeff. Note that this is over a month before the murder that Jeff observes this damage, so it was out there for a while. June 13th, the defendant has a note in her calendar to consider canceling Harvey's birthday party if that's what he wants to do. Now, this is between June and July trips, that there's a note to herself to talk to Harvey about whether or not he wants to cancel the party. Rob Adelson testified that there was no illness or anything going on in the family that he knew of that would potentially result in the canceling of Dad's party. This note may be contemplating that if the murder had happened on the June trip, that Harvey might decide it's not appropriate to go through with the party and we need to cancel these invitations. Wendy took a photo with Catherine Magbanowa on the beach 2 days after that note to self in the planner. Here she is in front of the South Beach condo, pictured with Catherine Magbanowa. That photo was taken June 15th of 2014. Wendy sends Rob a text with a picture of her and Jeff Lacoste. This is June 28th of 2014. She includes a request to her brother Rob not to tell her parents about her relationship with Jeff. This suggestion of a secret boyfriend later prompted Rob to suggest Jeff as a potential suspect to the FBI, a secret boyfriend. This was also a little odd that she sent this because Wendy never talked to Rob about her boyfriends, and also because Jeff had already met her parents several times. June 30th of 2014, the defendant comes and gets Wendy and the boys from Tallahassee to take them down to Miami. Remember how she doesn't let Wendy drive with the boys to Miami. She rents a car and comes here and picks them up and drives them to Miami herself. And I think Harvey comes with her. Wendy was to be in South Florida for 2 weeks. In the time between the June and the July trip, Charlie begins to put more pressure on Catherine Magbanowa to get the murder done. On several occasions when he and Magbanowa were discussing the murder, Charlie would step out of the room to call his mother and then return and advise her that the murder needed to get done as soon as possible because his parents were so stressed and worried about Wendy's situation. Charlie painted Dan Markel as an awful person to Catherine Magbanowa. He was making Wendy's life hell. He was stressing her parents. Katie knew somebody who could get this thing done, and he wanted it done. Magbanowa understood that the murder was needed urgently to relieve the stress on Charlie's mother. July 1st, 2014, we have a single call from Garcia to Harvey Adelson. This call did not connect. Appears like it went to voicemail. And we would later learn from Magbanowa that this was after an incident in which her two love interests Charlie Adelson and Sigfredo Garcia had a little bit of a run-in. Garcia was angry and jealous about Magbanua dating Charlie and tried to confront Charlie. After this attempted confrontation, it's believed that Garcia was trying to call Charlie, but ended up getting Harvey. And that was that one hang-up call, but it ended up being important because it showed up on the tower dump, Garcia's number, and then when we cross-referenced it with all the Adelson's numbers, that was the first match that gave us Sigfredo Garcia's name. We would later learn that the real connection between the Adelsons and the killers was Catherine Magbanua and her relationship with Charlie Adelson. The text messages found in Charlie's iCloud corroborate what Magbanua says about the interactions and the call made the day before. Here she's saying basically Garcia's being ridiculous and childish. Harvey's birthday Evite goes out on July 3rd of 2014. The Evite addresses the boys by the last name Adelson. Their name was Markel. This is 2 weeks before the murder of Dan Markel. Even though the Evite says hosted by Donna and the party was for Harvey, the defense has suggested that it was Harvey and not Donna that sent the Evites. The evidence showed otherwise, and Corbett told her some follow-up from Donna with the Evite people. She sent that email. A text is sent from Wendy's phone to Dan Markel on July 6th of 2014. At the time this text was sent, the phone was present at the South Beach condo where the defendant lived. Dan Markel confirms, yes, I'm going to be in town to get murdered. Not specifically, but he's asked, are you going to be in town July 14th or the 18th? Those are the dates the killers were here. And this, despite the fact that the schedule for that week had already been decided way before this text. And Wendy was already scheduled to have the boys on that Wednesday, which is what she's asking about. She doesn't ask about the whole week that he's got the kids. She only asks about the 14th through the 18th. And I think the killers ended up going to Tallahassee on 15th through the 18th. Obviously, Dan Markel was killed on the 18th. July 11th, 2014, the defendant comes back to Tallahassee to bring Wendy and the boys home. Okay, so bringing her home from Harvey's birthday party. That same day, both Harvey Adelson and the defendant separately, 8 minutes apart, email Wendy Adelson about her TV repair appointment that's going to happen on the day of the murder. July 13th, Wendy and Lacasse meet at Wendy's house, and she's an emotional wreck again for no apparent reason. Lacasse impeached her regarding some statements she made during a discussion of their relationship that evening in the context of, you know, you got to get past this moving to Miami thing. I mean, you're not going to be able to move to Miami. And she says, you know, yeah, it's not an issue unless something happens to Dan. And she says, can I tell you something in confidence? And she makes the chilling statement at that time that her brother, besides joking about hiring a hitman because it was buying a TV because it was cheaper than hiring a hitman, he also...
Donna Adelson is in the courtroom, ladies and gentlemen. I repeat, Donna Adelson is in the courtroom. Here we go, little towels. We do not have a feed yet, but I repeat, Donna Adelson is in the courtroom. That is a live look right now, little towels. Donna Adelson in the courtroom. We are dropping the clock. The clock is being taken off the screen, little towels. I repeat, Donna Adelson is in the courtroom. My name is Grant Smith Ellis. Donna Adelson sentencing for the murder of Dan Markel is about to begin. Harvey is there. If you were wondering, will Harvey Adelson make an appearance? Yes, indeed. There is Harvey Adelson. He has made an appearance. He is Harvey Adelson. Now, Donna, in her prison purple uniform, ladies and gentlemen, appearing up on your screen just seconds ago. Harvey standing there like a Harvey Adelson. He's a bit of a ghoulish figure, ladies and gentlemen. Yes, indeed, he is. Will Harvey be indicted? That is the question, alongside will Wendy Adelson be indicted on everyone's mind. Well, my name is Grant Smith Ellis. What tense moments we have here, ladies and gentlemen. I'm glad to be with you. Thank you so much, those of you who have tuned in. The sentencing for Donna Adelson is about to begin. If you missed it earlier, we did have a shot of Donna Adelson. For whatever reason, the court pool operator is now very, very interested in looking at Harvey Adelson. Now we have Donna Adelson. Ladies and gentlemen, our first look at Donna Adelson. She is a Donna Adelson. She's about to be sentenced for the murder of Dan Markel. Donna Adelson talking with her lawyers, Harvey Adelson being a Harvey Adelson. Now, my name is Grant Savellis. Thank you very much for tuning in. We are about to get started. We don't have any audio yet on this court pool feed, but the sentencing is about to begin. So I'll stay with you. I'll provide my erudite commentary. Will Donna Adelson get life in prison without parole, as is expected? We've had some debate today in the chat as to whether or not that's appropriate punishment. I don't know enough about the Florida statutes. I'm also not a lawyer. I'm a towel. I don't know enough to tell you, ladies and gentlemen, whether or not this is for conspiracy to murder one is the type of thing that gets you life without parole. I tend to think yes. The only people who haven't gotten that are the hitmen, and that's because they cooperated, and they were the only ethical people. Even though they were the ones who pulled the trigger, they were the only ones who didn't want to kill Dan Markel in front of his kids. Donna is in her prison purples. Here we go, ladies and gentlemen. It begins now. Donna Adelson waiting for Judge Everett to take the stand. It is mandatory. Life without parole is mandatory. I don't know how the others got away with the lower sentence. It must be some kind of plea bargaining. So it appears it will be a mandatory sentence of life without parole. I had no doubt about that personally, but I didn't know the Florida statute, so I'm not surprised to hear that. Thank you very much to Elijah Towell and to Colleen Henry and Commander Buck Towell. Hello, Commander Buck Towell and Colleen. How are you both doing? Thank you very much for that clarity. Donna Adelson obviously knows that this is a fait accompli, if that is what the statute requires, so I don't foresee much protestation. Nonetheless, ladies and gentlemen, we will watch these moments. We will take this feed live as soon as it does. Well, it is already live, but we don't actually have any audio. We are just looking at Donna and Harvey. So I guess that's what we're going to do. Little Towel's just going to tell you about how we're doing that. I expect Judge Everett to take the bench any second now. Here we go. All rise.
For Judge Stephen Everett presiding.
Afternoon, everyone. You can see that. I believe the defense had a witness that was going to be giving a statement of presumed sentient.
That's correct, Judge.
Is there anyone that is going to be attending on behalf of the state as well?
Yes, Your Honor. The Markel family will be appearing by Zoom, but they're relying on their statements previously made.
I won't read the phone number out loud, but his iPhone, one of the witnesses in this matter.
I believe the gentleman appearing as our witness, Judge, this case.
Judge, the 647 number belongs to Mrs.
You can tell her to rejoin.
Wilson.
Everyone on the Zoom can keep themselves on mute until it is time for you to speak, please. We're here this afternoon for final disposition and sentencing in case number 2023 CF 3226, State versus Donna Adelson. Parties can make their appearances.
Georgia Kappelman for the state.
Joshua's on for the defense.
Jackie Colford on behalf of Mrs. Adelson.
Have the parties received their copies of the pre-sentence investigation report?
Yes, Your Honor.
Yes, Judge.
Are there any objections that either party wishes to make to the pre-sentence investigation report?
No, sir.
There are corrections that would need to be made, Judge.
What are the corrections?
Would you like me to stand here at the lamp?
It's in there.
On page 1, they have the date of arrest as November 20th, 2023. And she was actually arrested on November the 13th of 2023.
I will notate that. Ms. Kappelman, is there any
No,
challenge
sir.
to those?
No, sir.
I will notate the copy then that will be filed with the clerk as November 13th of 2023. Go ahead.
On page number 5, there are several. The first place, near the top, it says wage, salary, and this was supposed to be her current employment that she had, and it said $1,000. She did not have employment where she made $1,000. She was not receiving any salaried income, so that should be 0.
Ms. Kappelman, do you wish to be heard concerning those?
No, Your Honor.
So again, I will notate the wage salary as $0.00.
Thank you, Judge. The next, underneath there, it says the number of jobs in the past 2 years, 1. She has had no jobs. She's been employed the majority of the 2 years.
Which part of page 5 are you referring to?
Well, that's on page 5, right underneath the wage.
So no jobs, no employment.
Correct, that should be 0.
Ms. Kappelman, do you wish to be heard?
No, sir.
Notate that there has not been any employment or 0. Go ahead.
Thank you, Judge. Directly under there, it says months unemployed in the past 2 years, 0, and she's been unemployed for 2 years.
Well,
No objection.
so you're asking for that to be 24 months.
Correct.
Go ahead.
There are 2 typographical errors in the remarks section. The second line from the top under remarks says history, comma, she. I believe that's supposed to say the defendant.
Give me one moment, I'm finding it. You said history is the first word leading into the correction.
History is right next to the word she. You see that's on the second line down. It says remarks, and then the word right under there on my copy says history, comma, she.
Yes.
It should be the.
Ms. Kappelman.
No objection.
Go ahead.
And then in the same paragraph, 4 lines down to the far right, it said who had fallen in. That should be ill, I-L-L.
No objection, Judge.
Go ahead, Ms. Wolford.
Yes, sir. Going down under the financial status to where it says estimated total debts. In the second line, it says a second mortgage was taken out to pay for their home. That should say legal expenses, not home.
No objection.
Go ahead, Ms. Wolford.
Yes, sir. The same section where it states remarks, 3 lines down, it says husband's dental practice. That's incorrect. The dental practice was not providing income prior to her arrest. She was only receiving Social Security assistance.
You're just asking husband's dental practice to be scratched through.
That's correct. The only income was, they listed Social Security, but they listed both.
No objection.
Well, anything else?
On page 7, Your Honor, about halfway down the page, it has the remark section. And if you go 1, 2, 3 lines from the bottom where it's listing grandchildren, on the right, it has a child's name, 14, and then it says a female, 7. That's actually a male.
No objection.
Right. Any other objections?
Not from the defense.
The court has reviewed the PSI report, and at this time I will direct the clerk to file it as a part of the record. Ms. Kappelman, do you have any other witnesses or evidence that you wish to present as a part of your presentation today?
I have some documentation regarding cost of prosecution, Judge. Would you like that at this time?
Yes.
The state has put together a summary page and a thumb drive. We are requesting $723,123.68 in restitution. Defense advised that they want supporting documentation regarding this request. which is contained on this thumb drive. They're just receiving it today. So have not had an opportunity to review it. I think at this time, the parties are in agreement to ask Your Honor to order cost of prosecution and reserve regarding the amount, and we'll see if we can reach an agreement regarding the amount.
Very well.
So that's one item that's in dispute for today. Another issue, Judge, is the score sheet. I've prepared 2 score sheets. May I approach again?
You may.
First includes death points, bringing the lowest permissible prison sentence in months to 172.5. The second does not include the death points, bringing the lowest permissible prison sentence in months to 82.5. It was brought to my attention yesterday that the defense objects to the inclusion of the death points. The limited research that I've had an opportunity to do suggests that they should be included if the death was a direct result of the crime. I believe it was. The defense wants to argue otherwise, so whichever score sheet Your Honor chooses to go with, they're both provided there for you. The state is requesting, are you ready for me to argue what I want for sentence? Okay.
Go ahead.
Obviously life on count 1, Judge. We would ask for 30 years consecutive to count 1 on count 2, and 30 years concurrent to count 2, but also consecutive to count 1 on count 3. I do not have any additional testimony or other evidence to provide, Your Honor.
We've had this issue of the death points being attached to the non-homicide offenses come up in other cases. Certainly the death points would attach if there were an offense that would be scored, but the first-degree murder is not being scored on the score sheet. What would be the basis, Ms. Kappelman?
That the death resulted from the conspiracy. It wasn't just a conspiracy without a death. It was a conspiracy that directly resulted in a death, hence the death points are appropriate.
What is the defense's argument concerning the score sheet?
I'll do my best, Your Honor, dealing with the weather for the last week or so. It's the same argument that was on behalf of Dr. Adelson. Post-conviction, Your Honor, granted the correction of the score sheet. Solicitation and conspiracy do not require an actual death. And I'll just rely on the same cases that were relied on by Dr. Adelson. State versus Johnson, 561 Southern 2nd, 1321. The crime, quote from that case, the crime of solicitation is completed when the actor, with intent to do so, has enticed or encouraged another to commit a crime. The crime need not be completed. And then in Becky v. State, 423 Southern 2nd, 417, 7 DCA, crime of conspiracy consists of 2 necessary elements: an agreement, 1, and 2, an intention to commit the offense. Once the intent is formed and the agreement is made, the conspiracy is complete. Just like Your Honor did in Charlie Adelson's case, by order that was not opposed by the Attorney General's office. I believe that order is dated January 24th, 2025. Your Honor agreed with that position and ordered the state to prepare a corrected score sheet without death points.
Well, Ms. Kappelman, my memory of this is in line with the defense position. Certainly, if the state wishes to take any appeal concerning the score sheet, that is your choice.
Understood, Judge.
Death points will not be added to the score sheet that is signed by the court. Is the defense ready to proceed with its presentation?
Yes, Judge.
You may proceed.
Would you like me here or at the podium?
You may remain at the table, or you can come to the lectern, whichever.
Okay, thank you, Judge. I guess we would start with the witnesses that we have. The one that's standing by on Zoom is Dr. Ben Graber, who would like to make a statement on behalf of Mrs. Adelson.
Dr. Graber, if you at this time can please turn on your microphone. Please raise your right hand, sir. Dr. Graber, if you can raise your right hand to be sworn. Do you swear or affirm the testimony you're going to provide today will be the truth? I believe you have a volume problem, Dr. Graber. I can see your lips moving, but I can't hear you. I guess just so I can test that we do have proper audio, Dr. Graber, before you get started, Mr. Markell, if you can turn on your microphone and say 1, 2, 3 for me so I can test this audio. All right, he's not coming through either. Time to troubleshoot.
Yes, but I didn't know what I was supposed to be doing.
Right. Dr. Graber, if you can say 1, 2, 3 while I test this equipment. All right, I can hear you now, but we can't get him over the loudspeaker. At least someone must have switched the audio settings. My mic's fine. It's the witnesses need to be heard. Right, thank you, Mr. Markell. I'm going to place you back on mute at this point. Right, Dr. Graber, try to talk for me one more time. 1, 2, 3.
1, 2, 3. 1, 2, 3.
Judge and a Radio Shack man, all in one. All right.
It's working?
It is. Let me swear you in again, sir. Please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your head. If you're examining the witness, or is he reading a statement?
He's going to present a statement, Judge.
Dr. Graber, you may proceed at this time.
Thank you, Your Honor. I appreciate the opportunity to come and speak on behalf of Donna Adelson. If I can, let me just brief description of who I am, my background. I've been a friend of the Adelson family since 1979. First 20 years I knew them, we were actively engaged in many activities. In the last 20 years, I haven't seen them that much until this trial became apparent to me. And my background is I'm a medical doctor practicing obstetrics and gynecology, 45 years here in Florida. I was also a state legislature from 1988 to 96, representing Coral Springs and parts of Broward County. I was the county commissioner in Broward County and mayor of Broward County for 1 year in 2006. Also a professor at the University of Florida Medical School and the University of Miami Medical School in clinical OBGYN. And I'm here to speak today on behalf of Donna Adelson, the person I've known for a great deal of time. Hi Donna, just want to say hi. I'm sorry I can't be there to hug you. And I'm sorry we didn't get to have that dinner after your trial was over. But I'm here to, on your behalf, to let you know that you have friends, and I believe in you. Let me say that, Tom, I never thought we'd be here at this situation when I first met you. It was a total shock to me and to our families. And it's a tragedy for me to have to be here to talk about this. I feel very bad for your family, for the Martell family, for the tragedy everyone's experiencing. To me, I've been following this for 2 years. It appears to be a dissolution of two families. My background is similar in many ways to both families. Like Ruth Martell, I'm the son of Holocaust survivors. I actually was born in Germany as a displaced persons camp. Came to the United States at the age of 18 months. So like the boys, Lincoln and Benjamin, I don't have a lot of recollection from the first beginning of my time in the United States, because they don't have the recollection of their father, which is very sad to me. But they do have families, and I had family. And we have to learn a great deal from our tragedies how to come back into life. My distress is not just for Donna and the Adelsons, but for the Martells as well, and especially for 3 generations of each family, which I see in tragic downward swing. And yet, I did meet Lincoln and Benjamin at the bar mitzvah last year, and I got to meet those 2 boys, wonderful boys. Unfortunately, I never got to meet Dan Martell, but I have read many of his articles. Very impressive, very brilliant, very talented man who made some very good points about the law and about compassion in the law, which he felt could be improved. And I agree with that. So part of what I'd like to say today is basically that I do believe that Donna is a victim of not just circumstance, but has been actively exploited by parties involved in this case. I believe she was exploited by her son. Knowing Donna, who was the youngest child in her family, and knowing her mother, and how close she was with her mother, and understanding their love and need for family, it makes no sense to me that she would pursue an activity that will destroy 2 families like it has. However, having known her son and some of his issues, I believe Donna, in her own naive way, trying to be a loving mother, is subdued by guilt, by silence, by denial, and perhaps even active exploitation, and used for activities she had no part of. So I believe she's innocent on all 3 counts, even though she was found guilty on all 3 counts. Part of my understanding is also that the victims here are both families, and to watch the hate and distress and the vengeance I see, it's a terrible thing to look at. As Holocaust survivors, you'd think we would understand that better, how damaging it is to families. I would have to say, my background, I grew up in the Bronx, went to the public school system. I actually was at Queens College when Donna was there, but I didn't know her. She graduated a year after I did. My wife Sandy graduated from Queens College as well. When we got to Coral Springs, we met up after being there a while, new young families, professionals trying to build a life, having children, building a community, which we did. So to see this situation occur, to me, it was devastating in many aspects. As a legislator, I can tell you that we see things in law. Even though I'm a doctor and I was chairman of healthcare, I was a Democrat, majority leader, and I sat on Judiciary Committee for 2 years. I understand the laws. Even wrote some of the sentencing guidelines and participated in passing them at that time. And what I learned over the years is that I had the privilege of passing many laws, because I was a leader and able to work both sides. And so many of my laws exist in the books. I get calls from judges periodically asking me about the intent of the law when I wrote it, because they have a case and it's come down to what did you intend to happen from this law. And they would ask my opinion, and they would use that information. So I'd like to look a little bit about the intent of the judicial guidelines for sentencing. I think the life without parole is a very harsh sentence. And that was not the intent, was to punish domestic cases with that, but to hit drug dealers and organized crime and dangers to the public. But I think it's been switched over to be used in conspiracy theories against the average citizen, which would not be the intent of the law, in my opinion. Second of all, I think that it's unfortunate that this case has gone into so many new victims. And we've already, you have 4 victims who have been found guilty of murder. 2 have committed murder, 1. The other are conspiracy theories. And I would believe that I would suggest that needs to be reviewed by the legislature. That's my opinion. Now, in this case,
Dr. Graber, before you continue, is this being offered as character? Because he's an expert on the law.
It's character, Judge.
Very well. You may continue, Doctor.
Yes, that's my opinion from my practice. I'm not giving a professional opinion, I'm giving my personal experience. What I'm asking the court today is, to me, the court, the judicial system, the power of the judicial system is in the judge. And it is the judge who is the presenter of a safety net for the public. To show some compassion on the cold written law, with every box checked off, shows no compassion. Where does the compassion come from? It should come from the judge, it should come from the jury. And I think that that's something we have to consider. So at this point, what I'm saying is that I believe Donna Adelson is a 5-star mother, did everything she could do for her kids, for her family, for her community. She has no bad intentions. She's not a leader, she's a baby in her family. She's always been the follower. Yes, she makes noise and she complains, but that's not her behavior. This is not her profile. So I understand that nothing can be changed, but I want to put on record. I believe she is innocent of these 3 counts, and we believe her. With that, I would have to say, sometimes bad things happen to good people, and I think this is one of those cases, and it's unfortunate. For the families, I would beg them, think about the 2 boys. Dad is not here, but a piece of him is here, and those 2 boys. And their future, they're both teenagers now, their future depends a lot on what's going on here, and how they're going to be perceived in the future, and how they will interpret the future based on this. So I think it's time for some compassion, some understanding, some forgiving. Perhaps it's time to take a step back and let everyone heal from this process. With that, I say to you, Donna, Anthony and I love you, we support you and the family, and we hope for you the best. God bless you. And Your Honor, thank you for letting me speak.
Defense have an examination for the witness?
No, Judge.
Does the state have an examination for the witness?
No, sir.
Dr. Graber, you can remain on the Zoom. I would just ask you to speak yourself at this point.
Thank you.
Defense have any other witnesses to present or evidence?
Yes, Judge. We have Rick Chagrin, who's present, who would like to make a brief statement.
Please raise your right hand, sir. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your hand. You may direct the witness or you may give a statement.
If you could state your full name, please.
My name is Richard Gordon Chagrin.
And have you prepared a statement here today?
Yes, I have.
Okay, you can do that to the court at this time.
This is on behalf of myself and my wife, Susan Brotman, an attorney at law. We have known Donna Adelson for over 35 years. She's been a dear friend and travel companion, and we are still in shock of her current circumstances. We know her to be a loving parent, wife, and grandparent. We stand behind her claim of innocence. We feel the trial was held in a county where there's been a lot of bad and inaccurate negative publicity, therefore not allowing a fair trial. We contend if a change of venue was granted, she would have been found not guilty. We are hopeful she will be relocated to South where she can do all legal remedies available. Thank you very much for your consideration.
These are character statements or quibbling about the evidence and the rulings?
It's character, Judge. They're here to talk about their friendship and time. Thank you.
Any witness examination from Ms. Chagrin?
Captain.
No, Your Honor.
You may be seated. Any other witnesses?
We did provide to the court, if you received your copy, Judge, some very short letters that were written as character support on behalf of Mrs. Adelson, and I may go through those at this time.
Go ahead.
Thank you. The first letter that was submitted to the court was by Annie Cunningham and Ronald Gutterson, who testified at trial. They say, "We are writing this letter to restate our knowledge and feelings regarding Donna Adelson. We have known Donna since 2009 and consider her to be our dearest friend. Donna is a kind, caring, loving person. She was always concerned with the welfare of others. She is not the monster portrayed by the media. Donna is incapable of threatening or harming anyone. Donna is almost 76 years old and in frail health after almost 2 years of incarceration. We will always believe her to be innocent and ask the court to take these factors into consideration when deciding Donna's sentence." Next, we submitted was one of her longtime friends, Ruth Rosenberg, who wrote, "I immigrated to the USA from Israel when I was 1 month shy of 12. I lived in Israel in a town of 5,000 inhabitants where my family knew almost everyone and came to New York City, Queens, with a population of close to 8 million residents. To say it was a culture shock is an understatement. I didn't speak any English and physically looked like an underdeveloped child in comparison to the American girls my age. I entered the 7th grade in September, not knowing any English, the quote stranger in school. For several months I sat by myself at lunchtime in the cafeteria, staring at the next table where Donna and a group of her friends were conversing, laughing, and having a nice time. One day, Donna walked over to my table and asked me if I would like to join them, and of course I said yes, please. That kind gesture started a 62-plus year friendship. She invited me to her house to meet her family, and over time we became like sisters. I can recall several instances where Donna helped me obtain a job so I can help my parents financially. She introduced me to a family in a bungalow colony in the Catskills who needed a mother's helper for their daughters in the summer of '66. The money I earned helped my parents pay for the closing costs on their house. The following summer, she got me a job as a counselor at Camp Allegra in the Berkshires. When I had to decide on a career path, I consulted with Harvey and Donna about applying to dental school as my college advisor had recommended. Later that year, I was chosen to be the maid of honor at their wedding. We remained close friends throughout the years, even though we lived more than 1,000 miles apart. Our families visited each other periodically, making sure that our children and grandchildren got to know each other. We attended life cycle events of our children, bat and bar mitzvahs, weddings, special birthdays, etc., and now our grandchildren's. Donna has always been a kind-hearted, generous, loving, and caring. She is one of my best friends, and I will forever remember and appreciate how she helped me with English while I helped her with math in Parsons Junior High School, and remained loyal through these 62-plus years. The situation she is in today is unimaginable to me. That is not the person I know and love. We also submitted a letter from Ron Ellis to the court. My name is Ron Ellis, and I have had the privilege of knowing Donna Adelson for more than 30 years. I am writing to you in hope of offering some perspective on the woman I have come to know so well over the course of our long friendship. Donna has been a steady and caring presence in my life. When my stepson passed away 11 years ago at the age of 34, Donna was there for me in ways I will never forget. She sat with me in my grief, listened when I needed to talk, and offered comfort when I felt overwhelmed. That kindness and empathy is the Donna I know. Someone who shows up for her friends and offers strength in their darkest moments. Over the years, I have seen Donna's compassion extend beyond just me. She has been a devoted mother, a loyal friend, and someone who consistently tried to bring warmth and generosity to those around her. I understand fully the gravity of the situation before the court, but I hope that when you consider Donna's sentence, you will also weigh the years of kindness, care, and humanity she has shown to others. I believe that Donna still has the ability to contribute positively, even under these circumstances, and that she is capable of reflection and growth. I respectfully ask that you take these qualities into account when you make your decision. Thank you for your time and consideration. Respectfully, Ron Ellis. And then a brief letter from Marion and Tim Schaffman. She writes, "We have known Donna for over 50 years, and although we live far apart and have seen her often over the years, we wanted to share with you our impressions of the lovely person we have known. Donna has always been a loving, kind mother and wife, and also an exemplary daughter to her parents, who often stayed with their family. We have never heard her utter a negative word about anyone, and had tremendous pride in every member of her family. She retained many friends from her childhood and developed long, satisfying friendships with the new people she met throughout each stage of her life. Donna was always intelligent, charismatic, and sensitive to everyone. She always listened to anyone's problems and offered a helping hand when she could. Most notably, her genuine concern over our and others' health issues was truly appreciated. As you can see, it is very difficult for us to view her as anybody other than the sweet, caring person we knew. Sincerely, Marianne and Ted Schaffman." Next is a letter from Jessica Ussery. "Dear Judge Everett, my name is Jessica Ussery, and I am writing this letter to express my personal experiences and knowledge of Donna Adelson's character. Donna and I share a beloved grandson, Roman Harvey Adelson, born in 2017. My first memory of Donna is a video made and shared on Mother's Day 2017. Charlie Adelson surprised his mom with the news that he and my daughter Brianna were expecting a baby. It warmed my heart to watch Donna's genuine excitement and happiness caught on video. Our families began spending time together as events and celebrations took place. I recall Donna being warm and welcoming. As I got to know her more, there was no doubt in my mind that she was a loving and devoted wife, mother, and grandmother. Roman's birth was a scheduled cesarean section on December the 5th. On that day, I was overcome with mixed emotions of excitement and fear. A family awaited Roman's birth at the hospital during unnerving procedure. Donna was affectionate and compassionate, as I was visibly anxious and emotional. I will always remember how she reassured and calmed me that day. We shared tears of joy and hugs when a beautiful and healthy boy came into this world. Donna was caring and supportive of Bree as a new mom. I have many fond memories of time spent with the Adelsons. Although Charlie and Bree were no longer a couple beyond Roman's first year, we all remained close. Donna has been kind, thoughtful, loving, and generous. Thank you sincerely for taking the time to read the letter, Jessica Ussery." And then a short letter to whom it may concern. "I've worked at Adelson Institute for Aesthetic and Implant Dentistry from October 3rd, 2011 to September of 2022. During my time of working there, I had the opportunity to experience the beautiful person that Donna Adelson is. Through my time of working often side by side with her, I've witnessed her grace and ability to diffuse upset patients. She is incredible with having compassion for others and is truly one of the sweetest people I know. She's so supportive and understanding when it comes to her employees. When an elderly person comes in as a patient, she always made sure they had assistance, whether needing help filling out forms or even opening the reception door for them. She always jumped at the opportunity to be kind and helpful. I witnessed this and I know it was sincere. I still use what I've learned from her and apply it while I'm at work every day. I recognize the gravity of the situation and understand the seriousness of the legal process, but I respectfully ask that you consider the positive qualities that define her. Sincerely, Erica Johnson." And then the last letter that we submitted from was Attorney Gary Cohn. He said, My name is Gary Cohen. I've been a member in good standing of the Florida Bar since 1980. I have known Donna and Harvey Adelson as personal friends and personal counsel for almost 40 years. Harvey was also my dentist for most of those years. I have been in the Adelson house, and they have been in mine numerous times over the years since their children were little ones. My wife and I have socialized with Harvey and Donna at dinners, blessed events such as bar and bat mitzvahs, and weddings, birthdays, and many other occasions. I've also traveled with them, including a wonderful trip to Africa with two of my sons several years ago. I therefore have had a unique opportunity to observe Donna under many circumstances. In all the time I have known her, I have literally never heard Donna raise her voice, lose her temper, act inappropriately, or treat anyone with less than full respect, and almost always with a smile on her face. I have never heard a bad word said about Donna from any other friend or person in my presence. She has always been an amazing mother to her children, and she and Harvey have had the most loving marriage that can be imagined. While I cannot comment on any of the facts of this case or any of the alleged events, I can say that the Donna I know is the last person I would ever think of when it comes to what has been this utterly horrible crime dealing with the death of Dan Markell. Being a trial lawyer for 45 years, I fully believe in the jury system and understand that a jury has spoken. However, the woman I've known so well for so long also needs to be understood as the wonderful wife, mother, grandmother, and friend that she has been known to me. I only hope that this information can be of use of the court when it comes to the sentencing of Donna Adelson, Gary Cohen. At this time, I believe that Mrs. Adelson's husband, Harvey Adelson, would like to address the court.
Very well. Do you wish to enter these letters into evidence?
Yes, Judge.
Does the state have any objections?
No, Your Honor.
They will be composite defense 1 for sentencing.
Thank you, Judge.
Dr. Adelson, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You can lower your hand. You may speak.
Thank you, and respected officers of the court, for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. December was our 54th wedding anniversary, and I had to spend it without her, hand in mine. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendy has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and social media.
Dr. Mrs. Fulford, this has nothing to do with the character of the defendant or relates to sentencing.
May I just 1 moment, please?
Go ahead.
Thank you.
I can't believe this is happening right now. First of all, I can't believe Harvey Adelson spoke like that. And then second of all, I can't believe Judge Everett just cut him off. What is the defense going to do? Oh my goodness. My name is Grant Smith Ellis, folks. This is crazy. This is the craziest thing I've ever seen. I can't believe this is happening right now.
All right, thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You're sending an innocent woman to prison. You have taken my wife, and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
You have an examination for Dr. Adelson.
No, Your Honor. No, Judge.
Any other witness statements?
I don't believe so, Judge.
What the hell just happened? I don't even know how to respond to that. That's crazy. Wow. That is wild. I've seen some stuff in my day. I've never seen anything like that.
We don't have any further witnesses, Judge, but Mrs. Adelson has decided she would like to make an...
Oh my God, she's going to speak!
Unsworn?
Yes, Judge.
All of the witnesses will be sworn this afternoon if she wishes to speak.
Judge, case law indicates, confirms that the defendant has the right to make an unsworn statement prior to sentencing. The court, Rule 3.720B states the court shall entertain submissions and evidence by the parties that are relevant to the sentence. A number of cases, Your Honor, that have interpreted this, especially in a capital case, as the defendant having a right to make an unsworn statement. This is a capital case.
Please give the citations.
Yes, Your Honor. Excuse me. First is Smith versus State, 268 Southern 3rd, 831. It's from the first DCA in 2019. You want me to continue, Your Honor?
Give me one moment.
Yes, sir.
Bring up my Westwell. Give the citation again.
Sure. It's 268 Southern 3rd, 831.
This is the issue of whether Donna can speak without being sworn in under oath.
Which pinpoint site are you referring to in the case?
That means which page of the case.
Let's see. Your Honor, I'm going to give you this one. It's Hill versus State, 246, Southern 3rd, 392. It's from the 4th District Court of Appeal.
One moment.
Yes, sir.
246 Southern 3rd, what's the last part?
392.
case where it does state the defendant has a right to make an unsworn statement, we will proceed.
Thank you, Your Honor.
Would you like Mrs. Adelson at the lectern or here?
She can remain at council table.
Thank you. I'm going to move the microphone. And then you speak loudly because this is not amplified.
Okay. Is this loud enough, Judge?
I can hear you.
Thank you for letting me speak. My son-in-law, Dan Markell, was a and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." The pictures and memories are all they have because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine Magbanaw's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning.
Before you continue,
That
Mrs.
revealed-
Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving Mrs. Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances, which are properly given to the appellate court. What does any of this have to do with sentencing?
Could I have just one moment, please?
This is wild. My name is Grant Smith Ellis. I'm watching this live with you. Donna Adelson has now been cut off twice, ladies and gentlemen, by Judge Everett. These are just absolute scenes. I have never seen anything like this in my life. Donna Adelson is, along with Harvey Adelson, was cut off as she's attacking the jurors, the witnesses, and Judge Everett wouldn't let her do it. Judge Everett said, "This is not an allocution. What is this? What are you doing, Miss Adelson?" And stopped her from speaking twice. My name is Grant.
Turn that phone off or step out.
Oh goodness, not a good time to have a phone ring. Oh, I just trembled in horror. Did you see me recoil in horror at that phone going off? Oh, this is so bad. I honestly don't know what to say. I can't believe she's doing this. He told her to stop.
When the phone is off.
see absolute scenes. I've never seen anything like this. I don't think anyone's ever going to see anything like this ever again. My name is Grant Smith-Ellis, and I am baffled. I am a baffled man. I'm a baffled towel. I don't know what to make of this. What is she doing? Why didn't she listen to Judge? Judge told her, I'm going to use this against you. You are showing an utter lack of remorse. She kept talking. What are you doing? He told you to shut up or change gears. You didn't. Then you started attacking the jurors. Are you out of your mind, Donna Adelson? Oh, God, Harvey Adelson had to get up and leave. Oh, that's absolutely brutal. Listen, this whole thing has just gone to hell in a handbasket. Oh, my God. I can't even believe what I'm seeing unfold right now. This is just absolutely incredible. Yep, no, I don't doubt it, Peach Pie, that Judge Everett is fair, but that was just a terrible moment for a phone to ring.
What happened to Danny is unforgivable. But I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with it. There are two crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loves him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, as I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way in Danny's murder. I was not.
Gents have any further argument to make?
Yes, Judge.
Judge, before Ms. Fulford makes, I want to address a comment that the court made a few moments ago concerning considering lack of remorse in fashioning a sentence. In Shepherd v. State 227 Southern 3rd, 746, the First District Court of Appeal held that lack of remorse cannot be considered in fashioning an appropriate sentence. If this were a situation where remorse and admission of guilt may be grounds of investigation, the lack of these factors cannot be used to increase the defendant's sentence, and such reliance violates the defendant's due process rights. And they also rely on Ritter v. State 885, 2nd 413, also a first DCA case.
I believe the Supreme Court has ruled on this issue concerning remorse and lack of showing remorse as well. If you need me to find the citation for you, I will.
Yes, please.
We'll take a 10-minute break.
10-minute recess. Listen, if you did not just see what went down, my name is Grant Smith-Ellis. That was, hands down, the most insane series of events I've ever seen in my entire life.
We'll resume at 4:16.
We will be back into session at exactly 4:16. Now, let me just say, I can't believe that just happened. I cannot, first of all, I can't believe after Harvey Adelson got scolded that times by Judge Everett, that Donna had the genius idea to get up there and do the same thing. And then Judge stopped Donna Adelson and said, listen, I am going to take your complete and utter lack of remorse right now for attacking the court, attacking the witnesses, attacking the jurors into consideration. This, in her brilliant wisdom, Donna Adelson then goes on and keeps doing it. She stops, talks to her lawyer at Jackie Fulford, and then keeps doing it. I was just astounded. And then Donna Adelson keeps going, and Donna Adelson starts attacking the jurors, the jury pool, the venue. Immediately, Judge cuts her off. And then Donna Adelson spends 3 minutes talking to her attorney again and finishes. Then, this was Donna Adelson's brilliant wisdom. Her attorney was under the mistaken impression that you can't take lack of remorse into consideration here. Judge Everett's immediately like, wait a minute, the Supreme Court of Florida said I absolutely can. I am going to go and get that citation. We're taking a 10-minute recess. Donna Adelson must have thought, because her attorneys told her that it didn't matter, she could just keep going because they had a case on it. Oh, well, you think Judge Everett just said that? You think he was just like, oh, I think I should be able to take remorse into consideration? No, he clearly had a case, and then he was like, oh, you want the case? I'm going to go get the case. Listen, you can't be wrong like that. Now, say Judge Everett comes back and says, oh, okay, well, I had this case, but it was overturned. Fine. Let me tell you right now, if Judge Everett comes back with good law from the Florida Supreme Court, he's going to punish Donna Adelson gratuitously for, one, her doing that, and two, her attorneys having the bravado to stand up there and say, well, Judge, this is actually totally permissible for her to just show a complete lack of remorse or contrition because the case law allows her to just, do that without any consequence. Yeah, okay, that's not a great argument to make to a judge if you're right. It's an even worse argument to make to a judge if you're wrong. Now, I'm not a lawyer. This is not legal advice. I'm a towel. But the point is, what a moron. What a moron. That lawyer. Now, we're in 6 more minutes of recess here. But what a moron. Judge telling you. Why would Judge just say that? You think Judge just interjects? This learned jurist, okay, bossy Texas chick's critiques about his speaking style aside, this learned jurist who has clearly been on the bench for like 25 years, are you out of your mind? You think, I'm talking about her defense lawyers, you think Judge Everett, is just going to get up there and interject his personal opinion? No, he's a judge. He knows what he's talking about. Listen to him. Why would you ever then advise your client that your plan is to drop case law on the judge? Okay, on the sworn statement thing, I understand that was the lawyer was right on a technicality, but that's a very minimum, de minimis pro forma thing. This is not. This is very weighty because, first of all, any sentence she's getting is a death sentence, basically. But, what's she trying to do? Induce the judge to have some anger at her she can get in the middle? He's not going to be unduly angry. He's now going to go in there. He's going to look at the case. He's going to find the thing about a complete lack of remorse, and he's going to nail you. I don't know why she spoke. I don't know why she had those witnesses speaking the way that they were. That was an absolutely insane strategy. I promise you, look at the commentary on this. Every single person that talks about this is going to say this was the most insane strategy they have never ever seen in their entire lives. I don't think anyone, anywhere was expecting that. Okay? That was absurdity. On a level that's hard to even comprehend or put into words, that was absurdity. It wasn't. Now, if Donna had just done it. Now, do you notice some of the character witnesses were actually character witnesses? If Donna had just allocuted, okay, I mean, she was never getting out of prison. Nancy, hello, my dear friend. If she's never getting out of prison, but let me just tell you, if she had just allocuted, at least she might have got a little compassion. I don't know why she did this. This was, first of all, Judge was telegraphing by cutting Harvey off, and the doctor before Harvey, that he was not going to let that shit fly. He was telling them, I'm going to cut you off if you start attacking the venue, attacking the jurors, attacking the witnesses. Harvey accused Dan's parents of perjuring themselves. like, it's wild. It was completely wild. And then Donna clearly did not get the message, or she was just so in the zone that she just decided to go up there after Harvey got scolded, and it just got worse. It got so, I didn't think it could get worse. That, like, if her plan was to make a PR statement, fail. If her plan was to influence, or like make Judge Everett like her, fail. If her plan was to get the media to cover her a different way, fail. There is not a single thing that came out of that was beneficial for Donna Adelson. Let me just tell you right now, I watched that whole damn thing. That was the craziest series of events I have ever... First of all, that was the craziest series of events I've ever seen in a legal trial. Second of all, she's a moron. It's not even like there was a tactical benefit to that. That was, I give up on this process. That was her saying, I give up on this. I don't care. I screw me, and just saying, screw it. Like, do you understand how balls to the wall, out of your mind you have to be to just be like, screw it? I mean, listen, I've seen some shit in my day, okay? But that takes the cake, ladies and gentlemen. That absolutely takes the cake. I'll never understand it. The only reason you would do that is literally if you were just so disillusioned with it all that you were like, I don't care anymore. And listen, I'm not saying that that's not what happened here. She may as well have been like, screw it. But I'm also telling you, I was listening to what her lawyer was saying when arguing to Judge Everett after this went down. The lawyer was like, oh no, you can't use this against her complete lack of remorse. And Judge Everett was like, yes, I can. No, that's where it all went to hell in a handbasket. Like, that's when you know you're like, oh, maybe this wasn't tactical. Maybe her lawyer's a moron. And then I'm like, okay, whoa, what is going on here and why? All right, so let me just tell you, that just absolutely blew Little Towel's mind in so many ways. Because I thought at first it was just tactical. You know what I'm saying? I thought it was just tactical, but then now that I process it as I'm uploading all these videos, I also understand her lawyer might have been under the mistaken impression that wasn't going to get used against her. Donna Adelson makes shocking attack on the court during her sentencing. Remorseless. I think remorseless is a good word. That's a hard word to spell. Hold on, let me work on that. Remorseless. Remorseless attack on the court during her sentencing hearing as all goes wrong. On the court during sentencing as all goes wrong. I have to come up with my titles in real time, you know what I'm saying? Alright, and then let me select a related video, can't I? Alright, okay. Add to playlist. John Adelson and Dan Markel. See, this is what it's like to be Towel. No. Alright, here we go. So, that's what it's like to be Towel. We're in recess, and Towel's being a little Towel. Alright, so Judge Everett is about to own Donna Adelson's soul. And you might be saying to yourself, well, sir, how do you know that? Well, because I listened to the exchange, and I'm just telling you, oh, wow, we hit 3,000 on the Towel X. You know, I'm telling you, folks, I was looking at it earlier, even early in the coverage today, we were at about 600. Some of the other bigger channels on the X were at about 300. Now we're apparently at about 3,000. And I guess I'll go over there and check the numbers. All right, Colleen Henry and Buck Towel being our unofficial reporter towels. Wow, we are tripling the next closest stream covering the hearing. Oh my word, Little Towels. Thank you so much for your support over on the Towel X. Now listen, we are not as big as Reuters, okay? We're still about 1,000 behind Reuters. But I'm going to go ahead and bring up this. Let me see if I can do this here. Hold on. Alright, I'm going to bring this up for you here, okay, and I'm going to put the feed on the behind Towel. Alright, hold on, we don't have to cover that now. Alright, hold on, Court TV should still be there. Yep, Court is not back in session. But we are apparently pushing upwards of 3,000 on the Towel X. I'm very pleased. Thank you very much for helping Towel Stream be one of the biggest true crime channels on Towel X. on the X, I should say, not just Towel X. And I will show you right now. Hold on, there it is. All right, so I'll put that behind my head. It's going to be in front of my head for a second while I get things set up here. But the point is, we are towels. All right, Judge Everett's back.
Gentlemen, were you able to review Davis?
Briefly, Your Honor, Davis was not a capital case. This is a capital case. Although the criminal punishment code would only apply to the non-capital cases, I would already submit to Your Honor that it is distinguishable under those circumstances.
Going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocated without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misdemeanors. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Very well. Any other argument or evidence the defense wishes to present?
Yes, Judge, thank you.
Please move forward.
Your Honor, we are aware that in count one, the court has no choice but to sentence Mrs. Adelson to life for the first-degree murder charge. We are going to request a downward departure as to counts 2 and counts 3, the solicitation and the conspiracy counts.
What are the grounds?
Pardon me?
What are the grounds?
Yes. The grounds are, one is non-statutory, and that's disparity in the treatment between co-defendants. And the second reason is statutory, and it is Florida Statute 921.00262B. The defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct.
The evidence in support of sub B will be the trial record, or do you have something more specific?
For 4B, we're going to rely on the trial record with respect to the conduct of Mrs. Adelson, and we would ask the court to take judicial notice. Your Honor did preside over Charlie Adelson's trial, and the evidence regarding the other co-defendants' activities or participation was also brought out in the testimony in the trial of Mrs. Adelson, so we'd rely on that record, Judge.
Ms. Kappelman, as to the argued grounds for statutory mitigation and also non-statutory mitigation, does the state have any argument to make?
No, Your Honor.
You may continue.
Thank you, Judge. I'll start with the disparity. Do you need case law citations for this, or you're aware of it, Judge? Okay. The first case would be Sanders v. State, 510 Southern 2nd, 296. This is a Florida Supreme Court case from 1987.
One moment. 510 Southern 2nd. What was the other part of the citation?
I have copies, Your Honor.
296, and that's Florida Supreme Court in 1987.
Go ahead.
State versus Fernandez, 927 Southern 2nd, 939, which is a third DCA case from 2006.
May I approach, Your Honor?
You may.
And then the third case, Judge, is State, I can't pronounce it, but State versus Kunkemoller, 333 Southern 3rd, 335. That's a first DCA case from 2022, but it is distinguishable because it does not address the issue of culpability as the first two cases do, but I wanted to bring that to your attention.
Judge Everett likes to have the lawyers work in open court, if you're wondering what's going on. Mr. Grant Spendelis, that's Toby Adelson, by the way. He looks like a disgruntled little turtle. You know, they call it TurtleBoy, but doesn't that man look like a disgruntled little turtle? You know what I'm saying? Look at him. Look at him. He's all snarly, angry-like. Got a little turtle face. He's a little turtle man. She's a little turtle woman. They're the real turtles. I tell you what, ladies and gentlemen. The Adelsons, they have been the real turtles all along. Yes, they are secretly turtles. And you might be saying, Towel, that is not true.
Thank you, Judge.
Yes, it
I'll start
is.
with the disparity argument, if I may, Your Honor. In this case, there have been several co-defendants who have either been tried or entered pleas and received sentences. I want to, for this particular argument, relate exclusively to Luis Rivera. He testified in the trial, and through himself and other witnesses, Your Honor has heard what he did in this case. And what he did in this case compared to what the state has alleged and the jury found Mrs. Adelson did, the culpability levels are very different. Mr. Rivera allowed to enter a plea to second-degree murder. Although, as the PSI indicates, he received a sentence of 19 years in the Department of Corrections, that was run concurrent with a sentence he was already serving in a completely unrelated matter in a federal case where he got a 12-year sentence. So the number of years that he will actually serve for his participation in the homicide of Dan Markell is 7 years in the state of Florida Department of Corrections. His conduct, as Your Honor can recall, is that he traveled to Tallahassee sometime in June and scoped out the home of Danny Markell, engaged in some drug activity with Sigfredo Garcia, and then returned to South Florida. A few weeks later, he returned to Tallahassee and again scoped out Danny Markell's house. But he didn't just do that. Prior to arriving in Tallahassee, with himself knowing that he and Sigfredo Garcia were going to kill Danny Markell, he purchased and provided the very firearm that was used to kill Danny. He came to Tallahassee and they sat in wait outside his home. They followed him with Mr. Rivera being the driver, followed him while he took his 2 little boys to daycare, and he sat and watched as Mr. Markell, hand in hand, took those children inside the daycare. He then followed Mr. Markell all the way to the gym, sitting in wait. What was he waiting for? He knew what he was waiting for. Mr. Markell did not. He had no clue that these men were outside in a car just waiting for him to go to a place where they could shoot and kill him. And they waited until he exercised. They watched him get back into his vehicle and then, like hunters, traveled and followed all of this time period straight to his home. And there was no hesitation. He knew exactly what they were going to do. Without any hesitation, they pulled right in behind Danny. Danny's car was still running, the garage door was up, and Sigfredo Garcia exits the car and shoots Danny Markel, having done nothing to these men, in the head twice. How Mr. Markel survived, I don't know. But then Luis Rivera is the getaway driver. They flee the scene, they flee Tallahassee, and then Mr. Rivera stops to allow Sigfredo Garcia to dispose of the murder weapon, which has never been found. And then he drives back to South Florida like nothing has happened, purchasing motorcycles and cars, but most importantly, getting paid for the work that he's just done. The payment came from Catherine Magbanua, and I'll address her in the next segment. The point here is, Judge, that over time, reading different things, you've heard a lot of arguments about what Mrs. Adelson's participation allegedly was. But when it comes down to it, and I didn't mention, but Luis Rivera did have an extensive criminal history at the time that he committed this offense. What actually came out at trial with respect to Mrs. Adelson, and I'm saying this, understanding, as you've learned, that Mrs. Adelson still maintains that she is innocent of this conduct. But what the state was able to show through their testimony and evidence was that the role that she played, according to them in the prosecution, was very minimal. The evidence showed that she was very upset when relocation was denied in 2013, not knowing that her daughter had agreed to it, not knowing that until she sat here in trial hearing her daughter's testimony. She wrote some very ugly emails. She said some very ugly things. But in not one of those emails did it ever say that she wished harm upon Danny Markel. And this was in 2013. The evidence was presented by the state that was over a year later that Danny was killed after relocation had been denied. Although they argued that there was continued hostility on the part of Mrs. Adelson regarding the issue of relocation, with the hundreds of thousands of emails they had, they didn't present evidence that this ongoing dispute was being brought up in any way between the parties. The relocation between them, that issue had stopped. The testimony that was elicited was that Charlie Adelson, the son of Mrs. Adelson, was the one who was close with Mrs. Adelson, and that when she had a problem, the argument from the state was, when she had a problem, Charlie was the problem solver. And the testimony at court that was presented by the state supported that theory, that Charlie was the problem solver. They further elicited evidence, testimony, that without any knowledge of what the phone calls were, Catherine Magbanua testified that when she was with Charlie Adelson discussing scenarios, which she didn't describe what scenarios she was discussing, that on occasion there would be a phone call between Charlie and his mother. She didn't hear the mother speaking. In fact, he left the room when he talked to, allegedly, the mother, and he came back in. He never relayed to her any information about the phone call. But the state's theory and the evidence that they presented was because Donna Adelson had been so upset about the fact that relocation was denied, and she continued to be upset, according to the testimony, that Charlie Adelson took it upon himself to reach out to someone, which was his girlfriend, and have her get someone that she knew who could commit this murder, make contact with them. According to the testimony in the state, in this case, Charlie Adelson told Catherine Magbanua, I'm not trying to be disrespectful, it's just as the names were reused, but Mrs. Magbanua, that she wanted him killed and he would pay for that to happen. Her testimony was she had no idea what the payment was going to be, but she did in fact reach out to the father of her children, Sigfredo Garcia, and he agreed to commit the homicide. Mr. Garcia then elicited Luis Rivera to participate with him in the homicide, and I'm not going to go through all the evidence in the case. I want to focus on what Mrs. Adelson allegedly did. Up until the point of the homicide, the only evidence that was presented about Mrs. Adelson's participation were those ugly emails. And there's a distinction, as we discussed during the trial and sometimes even at sidebar, of the evidence being up to the moment that Mr. Markel was killed. Up to that time, the only evidence introduced by the state in this trial for that time period were those ugly emails, and they were ugly. She called him very foul names. She said some ugly language. She clearly was not happy. And whatever conversations may have taken place while Catherine McBanowa was inside Charlie Adelson's home and Charlie was outside talking to another person. Mrs. Adelson maintains her innocence. But if you're looking at this particular cause of this disparity in treatment, the state is asking that Mrs. Adelson be sentenced to obviously life on count 1 as she has to be, followed by 30 years in the depressions on counts 2 and 3. This is far in excess of the sentence that was received by the man who himself testified to hunting down Danny Markel, providing the gun for him to be murdered with, leaving the scene of the crime, disposing of the murder weapon, and going on with his life in his gang as he always had. In that disparity, Judge, it just doesn't reconcile with the facts here of what they say Mrs. Adelson did. Although there was a theme that she was the mastermind, I would argue to the court that the evidence didn't show she was the mastermind in any way. The masterminds that were shown in this trial were Charles Adelson and Catherine McBanowa. It didn't show any activity prior to Mr. Markel being killed where Mrs. Adelson was involved in any way.
Take away what you're arguing as the theme for the moment. The chief difference between Luis Rivera and your client is he entered into a plea, correct?
That's correct. He did enter into a plea, but that, according to the case law, that can be considered.
And he has also cooperated with the state, testifying in many trials.
He was a cooperating witness testifying in these trials. Mrs. Adelson not only has maintained her innocence, she was never offered anything from the state.
Please continue.
On the statutory basis that the defendant was an accomplice to the offense and a relatively minor participant in the criminal conduct, some of what I've just argued applies to this one as well, Your Honor. But what I wanted to point out here were the ones that we didn't discuss. So Sigfredo Garcia was found guilty at trial, first-degree murder and conspiracy. His sentence was life on the homicide and an additional 30 years consecutive for a conspiracy count. He is the one who rode in the car. He is the one who obtained Luis Garcia to go with him. He is the one who sat in the seat knowing he was going to exit the car while they hunted down Danny Markel. And he's the one who got out and shot Danny Markel in cold blood. Left like nothing had ever happened. Along the way, made many stops, including getting out to hide the murder weapon, and then went on with his life. The killer is getting the same sentence that the lesser participant, the state is suggesting, get as well. Life in prison on count 1, followed by 30 years for the conspiracy and solicitation. Luis Rivera, I've already told you what his role was. Catherine McBanowa got the information from Charlie Adelson according to the evidence, and at his request obtained someone, Sigfredo Garcia, to do the killing. She is the one who coordinated between Charlie Adelson and Sigfredo Garcia and Luis Rivera. Although she testified that she didn't know Luis Rivera was involved until after it was over, the evidence that the state submitted clearly contradicts that. She was communicating with Luis Rivera before, closely to the homicide, and then shortly thereafter. She's the one that spoke to him. She was sentenced on the first-degree murder to life in prison, and on the solicitation and conspiracy, she was sentenced to an additional 30 years. It was run consecutive. Again, the same sentence that they're asking for on Mrs. Adelson is the sentence that this woman who heard the request for a homicide, found the person to commit the homicide, stayed in communication with both of the individuals who are responsible for killing Danny Markel, followed up with them and provided payment to them, and then took payment back from them for her to keep for herself. She was also paid in this. She participated, knew it was happening. They had proof that she knew it was happening. That was submitted to the court. All of that evidence clearly distinguishable from the conduct that they presented in evidence about what Donna Adelson did. Charlie Adelson, according to the testimony in this trial and his own, Charlie Adelson wanted Danny Markel dead. So on his close or very first date with Catherine Magbanawa, he asks her out in public at Halloween, some Halloween function, hey, do you know anybody who could get somebody killed? According to her testimony, she followed through with that. With Charlie Adelson, never with Donna Adelson, never communicated with her in any way about this. She worked then, if that's what happened and that's what's been testified to, she worked with Charlie Adelson from October of 2013 until Danny Markel was brutally killed in July of 2014. That entire period, and there's evidence, she admitted to most of it, to her conduct, and there's evidence that was presented in this trial and Charlie's that that's what happened. They made this plan, and that his stapled money was used to pay the killers in this case some $130,000 in cash that was divided up amongst Sigfredo Garcia. Sorry, my mouth was getting dry, excuse me.
Go ahead.
Thank you, Judge. It was divided up between Sigfredo Garcia, Catherine Magbanawa, and Luis Rivera. She then stayed in contact with Charlie Adelson. She convinced Charlie Adelson to get paychecks written to her, and she received those paychecks each time from Charlie Adelson. So for what Catherine Magbanawa did and what Charlie Adelson did, the evidence in this case shows it went far beyond what the state's evidence showed that Donna did, up to and including the time that Danny was killed. So again, if you're going to rate the level of culpability in this case and consider Mrs. Adelson's conduct as compared to those, they're asking that she get the same sentence as both of the people who killed, well, one person that did the killing, Sigfredo, a far more extensive sentence than Luis Rivera, who participated in the killing himself and only got 7 years. The same as Catherine Magbanawa, that apparently worked on this according to the evidence for many, many months and stayed involved even after that. Charlie Adelson is the only one who got a higher sentence. His sentence was life on count 1, the homicide, followed by 30 years on count 2 and another 30 years on count 3, so everything being run consecutively. The evidence that the state has presented is that Charlie Adelson is the one who masterminded this. That's what they've shown. Even though they said Catherine Magbanawa wasn't her trial, if there's somebody who started this, according to the evidence, it's Charlie Adelson, not Donna Adelson. All the work being done was Charlie Adelson. All the money that was paid was Charlie Adelson's money. Mrs. Adelson, according to the state's evidence, did not do any of that. Again, they had hundreds of thousands of dollars, or hundreds of thousands of emails. Never one in all of those emails that we all had to go through did Mrs. Adelson ever suggest any harm to Danny Markel in any way. I understand the verdict, and she has a right to take an appeal, and that's what she'll do. But the evidence in what was argued is very far different in theory than what was actually presented to this jury. And I'm requesting that Your Honor, in determining a sentence on counts 2 and 3, take into consideration that the amount of activity that everyone engaged in this case was far, far beyond what was alleged against Mrs. Adelson. They just didn't come up with the proof for that. They did prove to a jury that she was involved, but that proof and the actual evidence was very limited to the conduct that they say that she engaged in that resulted in Mr. Markel's death. I do want to remark, if I may, just briefly on the issue of remorse. Mrs. Adelson maintains her innocence, and as she has a lawful right to do, will seek an appeal. She may not get another trial. There may or may not be parts of the finding of the jury that is reversed. May not. They can do that on, the appellate court can do that on 1, 2, or 3 counts. There are lots of options that the appellate court has. The reason I say that is this. Mrs. Adelson, maintaining her innocence, could not have shown more remorse for the killing of Danny Markel. And in her statement, although some of it I know was bothersome to the court, in her statement, I hope you heard.
I wouldn't say bothersome to the court.
Okay.
Please continue.
Okay. I misread then. I apologize based on your comments. One of the things she said in her statement, after most of her statement being about the horrible thing that happened to Danny Markel, was that the people who were responsible for it were in prison. A pretty big state, considering what the state believes Mrs. Adelson's position is with respect to the others who've been prosecuted, convicted, and are serving sentences in the Florida Department of Corrections. I also want to say this. The defense's position in this case, from start to finish, has always been, on behalf of Mrs. Adelson, beyond respectful to the victim in this case, Danny Markel. He should not be lost in this case, and I said that in my opening statement. We presented evidence about a wonderful man he was. He did not deserve for this to happen. The Markels gave their statements at the conclusion of the verdict that was issued by the jury, and I listened to every single word. And every single word that they said came out of the terrible grief from the loss of their son and the feelings that they have developed over the course of this 11 years in prosecuting these various people and additional information that has been given to them. Every word they had every right to say. The feelings that they had are exactly what they should have. What happened to Danny Markel, as Donna Adelson has said in her statement, could not have been more horrific. He was treated like an animal, completely unaware that there was any kind of problem, that he would have any kind of physical altercation with anybody. I'm positive the furthest thing from his mind that day was that someone was going to kill him in his garage at his home. He did not deserve what he got. It's been very clear in our prosecutions and what was presented in Mrs. Adelson's trial about the conduct of these other individuals. They do deserve to be where they are. They do. Their conduct is unimaginable to me, that human beings would engage in that kind of conduct to bring a man, an innocent man, a well-respected man, an amazing father, to take him away from his mother, his father, his sister, most importantly, his children. That was horrific. I understand why those sentences were imposed. Not for Mr. Rivera, but for the ones that were tried and convicted. In this case, Judge, based on the evidence that was presented, the defense is going to ask on counts 2 and 3 that you sentence Mrs. Adelson to 3 years in the Florida Department of Corrections, counts 2 and 3 to run concurrently. My understanding in the court, the clerk can tell me if I'm wrong, but my understanding is Mrs. Adelson has 701 days credit time served. That's what we calculated.
I'll stipulate to 701, Your Honor.
Very well.
Anything more on counts 2 and 3, Judge? First of all, in order for it to assist Mrs. Adelson, she's going to have to be successful on count 1 on appeal. If she is, anything more than that period of time is going to basically be a death sentence for Mrs. Adelson. She is soon to be 76 years old. Her health has gotten worse while incarcerated, as anyone would probably expect. Her husband is 81 years old. Compared, 3 years compared to the man who participated in the killing getting 7 years, I believe is a just and reasonable sentence for Mrs. Adelson. We are also going to ask Your Honor, after imposing sentence, I know it's nothing but a recommendation, but we would ask if you make a recommendation to the Florida Department of Corrections that Mrs. Adelson be placed as close to Miami as possible, where her husband resides, so that she can have visitation. I understand we don't have any control over Department of Corrections, but we would appreciate that recommendation. And may I have just one moment, please?
Go ahead.
While she's doing that, Judge, I would ask that Ms. Adelson not be with Ms. McBano, or at least have a separation, if you could recommend that. I know Ms. McBano is currently at Lowell CI.
Yes, Judge, I thank you for that, Ms. Kappelman. I wanted to raise that issue because we did check into that. Judge, I contacted the Florida Department of Corrections. They did indicate that they would be able to keep them separate, but that doesn't necessarily mean that folks who are familiar with and friendly with Mrs. McBanois wouldn't be where Mrs. Adelson would be. So we are concerned about that, about her being placed at that facility. I didn't know it before, but the reception center for the women actually keep inmates there. I know that's a possibility, but again, that's in Ocala, and we're respectfully requesting that she be placed closer to Miami. Thank you.
Going to review the last case the defense has presented for downward departure. Ms. Kappelman, you had something else?
No, Your Honor, I don't.
Review the cases for downward departure, or in support of downward departure, the defense has argued.
Judge likes to work in open court sometimes, remember that. Crazy moments there. Donna saying she's worried about being housed near Katie McBano or any of her friends, just like Charlie. They ended up having to send Charlie to South Dakota because the Latin Kings put a hit out on him. You can imagine Donna just expressed indirectly similar concerns. And as I mentioned, Judge Everett likes to work in open court, so he will go to recess from time to time if he needs something that's not in front of him. But if he just has the documents and you give them to him, he's just going to read them. It's unlike a lot of other courts we watch on this channel. I'm sorry, I had to burp. That take recesses. Judge Everett just likes to work from the bench, and he expects you to sit there and be quiet. The attorneys can work and whisper, but he expects you all to just sit there and watch him work. Yep, let's send motion to send Donna to South Dakota. All right, hold on, we'll put up a poll. Should we send Donna Adelson to South Dakota? Buck Towell, what do you think? Commander Buck, should we send Donna Adelson to South Dakota? Sure, Buck Towell loves it. Sure, Buck Towell can guard her. You see what I mean? Buck Towell will guard Donna. No, send her to Siberia. No, send her to Siberia. All right, I put up a towel poll. Yeah, I agree, Peach Pie. I hope Harvey likes cold weather. All right, so the next poll is, should we send Donna Adelson to South Dakota? Your first choice is yes, Buck Towell can guard her. The other answer is no, send her to Siberia. It is a tie as things stand. Now listen, I don't know if Buck Towell's really cut out for this mission. Now, Buck Towell might be in NORAD, but listen, it's one thing to be in NORAD, it's another thing entirely to guard Donna Adelson. You know what I'm saying? One of them, you're mostly protecting the U.S. airspace. That's complicated. Guarding Donna Adelson, I mean, imagine having to talk to that woman. Oh, goodness, Buck Towell would lose his mind. We'd have to do it on shifts. We'd have to clone Buck Towell. You can't just make Buck Towell live with Donna Adelson. That's a form of doggy torture. You don't understand. Some element of the Geneva Convention probably protects Buck Towell from having to do that. You don't understand, ladies and gentlemen. I've thought this through. If we're going to send Donna Adelson to South Dakota, the only rational response is to have Buck Towel guard her. All right, everybody on the same page? What did Siberia do to deserve this? Oh, goodness. Buck Towel would like to let us know he's up to the task. Buck, are you sure? Buck's like, oh no, the TV's talking to me again. Buck, look it. Are you sure you are ready to spend the rest of your life with Donna Adelson? Buck, listen, have you seriously thought this through? Some form of donkey torture. Listen. This has been a ludicrous day. Wait till we get to the wrap-up. I don't even know what to tell you about some of the things that have happened today. Me saying that Buck Towel was going to guard Donna Adelson is one of the lighter things that has happened today. I don't think you understand. It was just we're not even at sentencing. Judge Everett's just like, I have some work to do. All of you sit there and be quiet. Well, you know what, Judge Everett? I'm going to use this opportunity as a moment of levity, and clearly, Buck Towel is now utterly baffled because he's now anticipating Donna Adelson to get transferred into his custody. He's going to have to go through training. Oh, goodness, he's going to have to be conditioned. There's going to have to be all sorts of... Listen, Buck Towel might be good at protecting the American airspace, but listen, I just don't know how we're going to get him to live with Donna Adelson. Now, first of all, we can't deprive Colleen of Buck Towel. First of all, just because he would be good at guarding Donna Adelson, you all seem to think that. Listen, we can't send her to Siberia. First of all, we don't own Siberia. There's probably a jurisdictional issue. Listen, I hate to break all of your hearts. There's probably a jurisdictional issue to sending Donna Adelson to Siberia. We don't own Siberia. Now, listen, we technically bought Alaska. All right, so people call it Seward's Folly. They did, but then it turned out we only paid like $7 million or something for it. Bro, that was a steal. I'm sure that was a lot more than $7 million in today's dollars. Rate of inflation from like 1880 or something till now. No, let's assume that's probably closer to like $300 million. But the point is, it was basically as good as the Louisiana Purchase. Okay, so we bought Russia, and where I'm going with this is if you want to buy Siberia, I am totally on board with it. What exactly we're going to do with it, I don't know. I don't think we should buy it just to send Donna Adelson there. I think that's a little... You want to talk about bossy Texas chick having concerns about the budget. You want to buy Siberia just so we can send... All right, hold on. Allie Towel would like us to note that if we buy Siberia, we will get the tigers. All right, I'm starting to see the plan. You want to engage in tiger diplomacy. Allie, I got you. Now I'm seeing this. We rent the tigers. We send them around the world on goodwill missions. We charge $1 million per year per tiger, and we own the breeding rights to the tigers. All right, I like how Allie's thinking about this. All right. That we will make Allie Secretary of Siberia.
Cases presented by the defense concerning the downward departure. Also, as well, the argument that has been presented, the court has reviewed its notes of the trial and rule on the issue of downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within section 921.0026, subsection 2, subsection B. In reviewing the trial court's notes, what has been argued by both the defense and also as well the courts relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markell to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub a Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 as a fine pursuant to section 775.083, $105 as the 5% surcharge required by section 938.04, $20 as the court cost pursuant to section 938.06, $3 as a court cost pursuant to section 938.01 subsection 1, criminal justice trust fund, $50 pursuant to section 938.03, crimes compensation trust fund, $225 pursuant to section 938.05, local government justice trust fund, $2 as a court cost pursuant to section 938.04, criminal justice education, $50 as a court cost pursuant to section 775.083 subsection 2, county crime prevention, $65 as a court cost pursuant to section 939.185, county additional.
Come on now. Come on. Oh, they ended the feed. I was wondering what happened. Hold on, they may have ended the feed. We do not control that. Hold on, I'll get a backup feed. I will get a backup feed, ladies and gentlemen. I will get a backup feed. As you can see, that was not us. The court TV feed just went down. I will go check the law and crime feed. That was not us. That was not us, folks. That was not us right at the very intense moment there, but I have got the backup feed. Get over to your screen now. It's loading. It is loading.
We have put the.
There you go, backup
I had
feed.
written on the letters that I had.
That's a backup feed.
So we put a deposit together, and I've shown it to Mrs. Kaufman, who has no objection.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess.
All right, there you go. We missed a little bit of it. Hold on, though, tell friends we're going to run that back, so we'll watch the part that we missed, okay? Just a few minutes here.
Crimes compensation trust fund, $225 pursuant to section 938.05, local government criminal justice trust fund, $2 as a court cost pursuant to section 938.15, county criminal justice education, $50 as a court cost pursuant to section 775.083 subsection 2, county crime prevention, $65 as a court cost pursuant pursuant to section 939.185, county additional court costs, and $3 as a court cost pursuant to section 938.19, team court assessment.
Is there any lawful objection by the defense to these assessments?
No, Your Honor.
They will be assessed at this time. The cost of prosecution, the court will reserve jurisdiction on to determine for 60 days. If a hearing needs to take place concerning this matter, that will take place at a future time. As the defense's request for the court to make a recommendation to the Department of Corrections to place Mrs. Adelson in a facility near Miami-Dade County, I have no problem making this recommendation. The Department of Corrections will have the final say because this is an administrative matter. I will also recommend to the department that Mrs. Adelson is not to be placed in any unit or facility that would also house Catherine McBanawa. The court did previously award to the state, based on the September 17th, 2024 continuance of the trial, costs that were related to that. Ms. Kappelman, part of what you're seeking to sue, is that included within that, or is that a separate number?
Are you speaking of the costs that were ordered in Charlie Adelson's trial?
No. The day Daniel Rashbaum withdrew from the case and the trial had to be continued.
Okay.
All costs related to moving witnesses and other matters.
Yes, sir. I don't know the answer to that, but I'll make sure that they're only in there once.
Very well. The defendant is to be fingerprinted, 30 days to appeal. Please file the appeal promptly.
Your Honor, may I approach the clerk? We have put I had written on the letters that I had, so we put a composite together and I've shown it to Mrs. Kappelman, who has no objection.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess.
All right, folks, so it wasn't you. One feed went down, the other feed stayed up. We were able to watch it. My name is Grant Smith Ellis. We're going to do our recap. So if you just tuned in, Donna Adelson has been sentenced to life in prison without the possibility of parole. What a wild series of moments, though, during that kerfluffle, during that sentencing. Harvey Adelson getting shut down by the judge, Donna Adelson getting shut down by the judge. We're going to watch it all during our recap. My name is Grant Smith Ellis. Thank you very much for being with me. You got a few minutes. If you missed it, you will get a chance to see all the developments during the recap. Don't worry about that. Feel free. Take a second or two to breathe. That was a wild moment. Another moment of vindication for the Markell family, but just a wild strategy on display by Donna Adelson. And we will talk through it. We'll talk about it. I got the clips. I have the videos queued up. We'll watch it together. It was just wild. I don't even know how to describe that. Donna's going off to jail now. We had a poll taken whether or not you all think Donna Adelson should go to South Dakota under the custody and control of the Honorable Commander Bucktowl, or whether Donna Adelson should go to Siberia. Now, I'm not really sure about the practicalities of literally buying Siberia for the purposes of sending Donna Adelson there. Now, Allie and Rue have tried to convince me that we should purchase Siberia because we'll get tigers and then we can loan them out for some kind of international towel tiger-based diplomacy. Now, I think Russia would probably not want to sell us Siberia right now. I mean, they got some stuff going on. They don't really like us. I'm pretty sure they're communists, like secretly communists, you know what I'm saying? They're just going to walk up one day and be like, listen, China, we're actually the USSR. They're going to turn around and be like, we're commies, we're all screwed. I don't think the commies are going to sell us Siberia. However, we can send Donna to South Dakota. It's cold in South Dakota, and think about it this way, Commander Bucktowl will be able to watch Donna. And you might be saying to yourself, Commander Bucktowl is a dog that works for NORAD. You can't just have him monitoring Donna Adelson. Well, if you think about it, Commander Bucktowl has always wanted to serve his country honorably and nobly. So what better way, short of, sending Commander Bucktowl further into NORAD, to have him serve his country? It's a sacrifice. We understand that, Commander Bucktowl. You're still going to have to do it. All right, somebody's got to do it. It's not pleasant, okay, but it could be worse. All right, you could have to watch. Well, I guess it's pretty bad, actually. You could have to watch Oh goodness, that guy from Long Island that buried those bodies. You could have to watch him. I guess that would suck pretty bad. You could have to watch Ghislaine Maxwell. Sounds pretty bad. You could have to watch her. She does a lot of pottery. I don't think Commander Bucktowel's into pottery. Anyway, we're going to do our recap in a second here. What I'm actually doing is getting this video ready to be uploaded to YouTube. So let me do that. All right, we're going to all do this together. We're going to be good little towels. Then we're going to do our recap. You'd be surprised. I multi-towel quite often. All right, I sit here. All right, my brain works fine. I can use my little opposable thumbs. And I go over to the towel phone. I'm uploading things, clipping things, putting them on Twitter, putting them on YouTube, being a little towel. All right, everybody ready for the recap? Give me like 30 seconds. What should we call this? Donna Adelson sentenced, please, to life in prison, no parole, plus 30 years for Dan Markel's death. You can't say murder on YouTube in a title. They don't like that. All right, here we go. Let's do that. Let's do that. There we go. Done. All right, let's do our recap. Who's ready? I'm a little towel. You're a little towel. All right. Here we go. Oh, no, listen, we're having some resistance from the South Dakota delegation about sending Donna Adelson to South Dakota. Well, all right. I didn't really consider that we'd have to negotiate with the South Dakota delegation. This wasn't part of my plan. I didn't really think about it. I'm not going to lie. I don't want to offend the South Dakotan delegation, but I'm just saying I wasn't really prepared for that. The other thing is, did you know we are at 5,000 on the Towel X? I would just like to say this is a historic day to be a towel. We have hit 5,000 people on the Towel X. Congratulations, you are all towels. All right, let's do our recap. We haven't had a recap in a while. I think I can do it. I'm feeling it. I haven't seen you all in a while. It's great to see you. I'll see you again Wednesday for a CCC meeting. But between now and then, it's time for a recap. All right, so I got to do some more negotiations with the South Dakota delegation. I don't know if we're going to be able to fulfill that condition. We need the blue slips, from the South Dakota delegation. You can't just send Donna Adelson to South Dakota. All right, we got to get some South Dakotan, other than Commander Bucktowel, who would just agree to do it, I'm sure, to agree to this plan. All right, let's get ready here. All right, what are we doing? Oh, yeah, we got to get all those videos up so we can watch our towel recap. All right, here we go. I'm ready. I'm a little towel. All right, I want this one. So what's the easiest way to do it? I think we select this. All right, that's how we do it. You ready for this? We're going to get all of our little videos up, and then we're going to watch them. All right. There we go. There's Judge Everett. All right, so give me a second. Let me get it all prepared for our recap here, because, yes, you're watching the recap in real time. Yes, people can watch the recap as well on the replay, but to actually do the recap, I have to mark it, and I have to get my videos ready, so give Towel a second. All right, here we go. There we go. That's good. All right, that's good. You can get all these videos on Twitter, of course. However, if you want to watch them with me right now, we can do that as well. All right, so there you go. Double towel. Everybody loves double towel. We don't need double towel, actually. We can just do this. All right, there we go. We don't need, hold on a second. Yeah, we don't need that. And then we don't need the Venmo. All right. There, see what I'm saying? Real-time video editing. That's what it's like watching Towel stream. All right, so here we go, and there we go. All right, I'm ready. You're ready. No, I think that can look better. Why can't we just bring that up a little bit and then bring this down a little bit? All right. There we go. I'm ready. All right, so let's get ready to cue the recap. What time is it? It is 5:13. So let's say recap cue 5:13 p.m. Okay, let's try not to do too long. All right, everybody ready? All right, hello. My name is Grant Smith Ellis. If you missed it today, the breaking news is that Donna Adelson has been sentenced to life in prison without the possibility of parole, plus a sentence of 30 years to be served consecutively for the conspiracy to murder law professor Dan Markel. Of course, Dan Markel was the ex-spouse of Donna's daughter, Wendy Adelson. And today, following a multi-year, 9 to 10 year process that saw Donna's son Charlie sent to prison, that saw the two hitmen, Luis Rivera and Sigfredo Garcia, sent to prison, that saw the middle woman in the transaction, Katie Magbanua, Charlie Adelson's, one of his former partners with connections to the Latin Kings, sent to prison. And then we saw Donna Adelson sent to prison. But in what could become a potentially ominous forewarning, we saw Donna's husband, Harvey, stand up before Judge Everett and try to relitigate the case. Harvey shockingly began attacking jurors and the system and the change of venue motion that was denied by that man, Judge Everett, who has presided over both Charlie's trial and now Donna's trial. Furthermore, the big question remains, will it be Wendy Adelson that will be charged next? Will it be Harvey Adelson that will be charged next? Harvey Adelson certainly did himself no favors today with the way he behaved in front of Judge Everett. We're going to watch it all, but let's start with the moments that saw Donna Adelson sent to jail for the rest of her life, ladies and gentlemen. Life without parole, plus 30 years to be served consecutive for Donna Adelson at the hands of Judge Everett.
Coordination to bring the murder of Professor Markell to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without a possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
There we saw the recitation of the fees and the costs. Now, we will watch the Harvey Adelson moment. It was just absolutely stunning, ladies and gentlemen. I'm going to bring it up for you right here on your screen. My name is Grant Smith Ellis. You're going to see us scroll a little bit till we get to the video of Harvey. And by the way, thank you again to the 5,000 of you that checked in over on the Towel X today. Those are big numbers for Little Towel, ladies and gentlemen, and I am grateful for all of your support and compassion. Let us take a look at the video of Harvey. I know I have it uploaded. All right, here it is. Is this it? Nope. Wait a minute. Where's the video of Harvey? I have it. I know I uploaded it. It'll be a video, not a live. Yes, here it is. I got it. See what I mean, Little Towels?
Will be the truth.
Towel always gets his Harvey Adelson clip. All right, so let's go down a little bit. Why is it like that? I wanted it to be the same as... Oh, I know why. Hold on one second. All right, one second. Let me center it. All right, thank you. That should be close enough. All right, so this is Harvey Adelson, folks, speaking at Donna Adelson's sentencing, and we're going to take a listen to this right about now. And this was quite a moment. If you were watching live, there was a lot of oh my goodnesses in the chat, whether from Colleen Henry, Buck Towel, or otherwise. It was a wild moment. Let's watch it. And let me turn this audio down. I don't want to spike it too much, but the audio is not always the best on these recordings. So.
Will be the truth.
Yes, I do.
You can lower your hand. You may speak.
Thank And respected officers of the court for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. Summer was our 54th wedding anniversary, and I had to spend it without her, hand in mine. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendy has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and social media.
Doctor, Mrs. Fulford, this has nothing to do with character of the defendant or relates to sentencing.
May I have just 1 moment, please?
Go ahead.
Just 1 second, please.
I can't believe this is happening right now. First of all, I can't believe Harvey Adelson spoke like that. And then second of all, I can't believe Judge Everett just cut him off. What is the defense going to do? Oh my goodness. My name is Grant Smith-Ellis, folks. This is crazy. This is the craziest thing I've ever seen. I can't believe this is happening right now.
All right, thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You are sending an innocent woman to prison. You have taken my wife, and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
That was all he had to say. Now, we are going to look at Donna's... I cannot believe Harvey Adelson called Judge Everett biased. That was ridiculous. That no wonder Judge shut him down. My name is Grant Smith-Ellis. That was just a foreshadowing of the unbelievable moments that Donna Adelson then brought upon us by speaking at her own sentencing. Not sworn, but still, these were wild moments. This was the the sentencing was the culmination. But the fact, watch how this plays out. I don't care if you are a learned trial observer or someone new to this discipline, or you just watch this because you find these cases interesting or because you want to see justice delivered. I have never seen anything like this. Remember, we just saw Donna Adelson's husband, Harvey, get scolded for attacking the prosecution and the witnesses and the judge and the jury and the forum, where the case was heard, okay? We just heard that happen. That was a preview. Mind you, that was the second warning Judge Everett gave when Dr. Gruber, one of Donna's first witnesses called as a character witness today, got up there. He did the same thing. And Judge Everett stopped him from speaking. So I'm telling you, Donna should have known, her attorney should have known, and we're going to find out at the end of this section, that Donna's attorneys were under the mistaken impression that she could just get up there and show no contrition, and it couldn't be held against her. I'll tell you right now, it was held against her, and Judge Everett's going to tell her that midway through. Donna herself chose to speak. She won the argument of not having to do it under oath. She chose to speak, and look what she does. I cannot believe that this woman did this. She goes down the exact same path as Harvey, gets scolded by Judge, not just scolded, directly told her utter lack of remorse is going to be held against her, and then she just keeps going. And he has to, Judge Everett has to stop Donna again, and then she keeps going. It was baffling, and it was not out of left field. Judge Everett telegraphed that he was going to do this. During Harvey's statement, during Dr. Gruber's statement, Judge Everett was saying, don't do this. Donna then goes up there and does it. And you can tell it did her no favors to get up there and fake talk about Dan Markell and how much she cared about his life. She immediately stops crying, goes into attacking the court, and then gets shut down by Judge Everett. You'll hear my real-time reaction. I couldn't believe what I was seeing, ladies and gentlemen, or hearing. You're now going to see it. This was wild. Those of us in the chat who watched this whole trial, watched the moments where Donna decided not to testify, tried to make it into a game. We were waiting to hear what this woman had to say. My goodness, for it to be this was as bad as possible. This was watching the good ship Hindenburg not just go down, but literally just stop midair and then fall to the ground. It may as well have been a scene out of Wile E. Coyote. Okay, I've never seen anything like this. I don't mean to add a comic level to this, but I'm trying to prepare you for what you're about to see. It's so fake, her contrition at the beginning, and then it immediately turns down the exact same path that Harvey was told not to go, and she just implodes. Donna. It's more than just having a meltdown, as many people predicted. She implodes herself and starts just arguing the merits of the case. You have to see it to believe it. That's the best intro I can give you. Take it away, crazy lady.
Thank you for letting me speak. My son-in-law, Dan Markell, was a and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." But but pictures and memories are all they have, because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is, they call, the quote, mastermind behind this murder. In both of Catherine Magbanowa's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue, Mrs. Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving Mrs. Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zollman, again, this has nothing to do with elocution of any sort. This is a raising of grievances, which are properly given to the appellate court. What does any of this have to do with sentencing?
Grab just one moment, please.
This is wild. My name is Grant Smith-Ellis. I'm watching this live with you. Donna Adelson has now been cut off twice, ladies and gentlemen, by Judge Everett. These are just absolute scenes. I have never seen anything like this in my life. Donna Adelson is, along with Harvey Adelson, was cut off as she's attacking the court, the jurors, the witnesses, and Judge Everett wouldn't let her do it. Judge Everett said, "This is not an allocution. What is this? What are you doing, Miss Adelson?" And stopped her from speaking twice. My name is Grant.
Turn that phone off or step out.
Oh goodness, not a good time to have a phone ring. Oh, I just trembled in horror. Did you see me recoil in horror at that phone going off? Oh, this is so bad. I honestly don't know what to say. I can't believe she's doing this. He told her to stop.
When the phone is off.
See, absolute scenes. I've never seen anything like this. I don't think anyone's ever going to see anything like this ever again. My name is Grant Smith-Ellis, and I am baffled. I am a baffled man. I'm a baffled towel. I don't know what to make of this. What is she doing? Why didn't she listen to Judge? Judge told her, "I'm going to use this against you. You are showing an utter lack of remorse." She kept talking. What are you doing? He told you to shut up or change gears. You didn't. Then you started attacking the jurors. Are you out of your mind, Donna Adelson? Oh, God, Harvey Adelson had to get up and leave. Oh, that's absolutely brutal. Listen, this whole thing has just gone to hell in a handbasket. Oh, my God. I can't even believe what I'm seeing unfold right now. This is just absolutely incredible. Yep, no, I don't doubt it, Peach Pie, that Judge Everett is fair, but that was just a terrible moment for a phone to
What
ring.
happened to Danny is unforgivable. But I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with it. There are two crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for death. It's not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this.
and it did not. It basically ended there. It did not go well for Donna Adelson. If you missed it, we'll end the recap the way that we started with the sentencing from Judge Everett. It just all crashed for Donna Adelson. A terrible decision, a terrible moment for her, a terrible, terrible approach, and this is how Judge Everett decided to render his ruling, if you missed it earlier.
Coordination to bring the murder of Professor Markell to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
All right, folks, my name is Grant Smith Ellis. You saw it there. Donna Adelson sentenced to life in prison without the possibility of parole for the murder of Dan Markell, plus 30 years to be served consecutively to that sentence. Is there more coming? Wendy Adelson, will she be indicted? Harvey Adelson, after his performance today, will he be indicted? What is next from Georgia Kappelman and Sarah Dugan for the state's attorney's office in Florida? Who knows? Are they well rested and ready to move forward with another indictment? Time will tell. We have a towel poll to end our recap before I say goodbye to the towel friends. Where should we send Donna Adelson? Donna Adelson is one. Most people, 59%, want to send her to Siberia. 41% say Commander Bucktowl can guard her in South Dakota. Love 7 Loyalty MHA asks, can you break down how many years that is? Well, it's basically infinite years because she has to serve life without parole. And then if she somehow, I guess, dies and gets reincarnated, then she has to serve 30 more years because it's life without parole plus 30 more years. It's actually 30 more years plus 30 more years, but those 30 years get to run consecutive. So it's technically an infinite sentence. I don't really know how to answer that question. She's technically in jail until she dies, and then if she dies and gets reincarnated, she has to go back to jail for 60 years or 30 years. So I guess the answer is infinite. She is in jail for an infinite amount of time, and if she somehow dies, she has to go back to jail. Now, I'm not aware of anyone since Jesus who has died, come back to life, and went on about their day. Well, Lazarus, I guess, technically. But technically, Jesus, I'm pretty sure, died and came back from the dead after Lazarus. So technically, the last person I'm aware that died, came back to life, and went about their business was Jesus. I do not think Donna Adelson is Jesus for a number of reasons. One, she was involved with killing someone. Jesus flipped some tables over when he was mad about people in the temple. He never killed anyone, so she's not Jesus. All right? It's just a very logical proof. Jesus never killed anyone. Donna Adelson killed someone. Therefore, Donna Adelson is not Jesus. As such, Donna Adelson is 99.99999% certain to not die and come back to life. And therefore, her sentence is eternity. She has to die in prison. Now, I want to leave open the small chance that somehow this woman manages to die and come back to life. If that happens, I don't think it's ever happened before, she might technically be able to get out of prison, and then she has to go back to prison for 30 years. All right. Oh, yes. Allie would like to let us... Oh, my pleasure, love, 7 loyalty. But Allie would like to let us know, technically, there might have been some zombies at a certain point in time where that happened to. Now, Allie, I don't really know a lot about zombies. I watched the movie 28 Days Later one time. That doesn't really make me an expert in zombies. I'm more of an expert in Jesus. So as far as I'm concerned, the last person to die and come back to life was Jesus. And I'm certain to a reasonable degree of towel scientific certainty that Donna Adelson is not Jesus. So therefore, she's going to die in prison. All right, good. We all on the same page? Little bit of a detour from what we were talking about, but somewhat on point. All right, so in short, Donna Adelson is going to prison for the rest of her natural life. She is not going to get out of prison, and the big question is, who is going to be charged, indicted next? A lot of people think it's going to be Wendy. A lot of people think it's going to be Harvey. I think only Georgia Kappelman and Sarah Dugan really know the answer. My name is Grant Smith Ellis. I'm going to go talk to the Towel Friends for a little bit. It is about 5:45. Let's end this recap. That was a good 30-minute recap. Thank you so much for watching. At the end of the recap, let me just note this is a public information service. It's designed to educate, inform, and entertain the wider public, such as to engender cogent public discourse and ward off the usurpation of our representative forms of government worldwide. There's no ads. There's no sponsors other than the ads that YouTube runs. There's no ads. There's no sponsors. There's no conflicts of interest. It is just me doing this because I feel informing you is important. It costs me a lot of money. I have to spend money on software and hosting and all this other stuff. A lot of other streams, they have their own ways of raising funds. I don't do that. I just tell you, here are the costs. It's a user-supported aggregate. You want to help out, you don't have to pay to do it. You can like, you can subscribe, but what keeps it going is the user support. If I just constantly lost $500 a month, I don't think I could really do this, okay? But you all help me live and not starve. God bless all of you. Furthermore, some announcements at the end of this recap before I go talk to the Towel Friends. Tomorrow, Tuesday, October 14th, we will have a towel trivia stream. I've decided I can do it, all right? I have to go to the doctor tomorrow morning. If we do the test and Towel's feeling all right, I'm going to come sit with you and I'll tell, if it's good news, I'll be in a good mood. If it's bad news, I'm going to be in a bad mood. Either way, I'm going to want to talk to you. So we're going to talk. All right, Towel will go to the doctor in the morning, and then we'll do towel trivia. Bossy, Texas Chick, and Bella are literally running around in their house right now. You don't understand. Bella is running in circles. Bossy, Texas Chick is chasing her because I'm talking about trivia. Now, Rue and Toffee are conspiring right now because they have plans to take over the entire state of Massachusetts. Rue thinks he can be mayor of Massachusetts. That's not really a thing. But as we found from our research, dogs have been elected mayor in various cities and towns around the United States. So mayor of the area of Boston sounds good. Don't vote Mayor Wu, vote for Rue. We've talked about this. Now, Rue's also very excited. Toffee Towel's excited. Oh, Toffee Towel, hold on one second. Now, you might be saying, sir, you're still technically in the recap. Why are you getting Pete Bunny Towel? Well, listen. Pete Bunny Towel would just like to let you all know that he doesn't like the communists, and also he likes Toffee Towel. Now, Toffee Towel is not Donna Adelson. Toffee Towel is a bunny, and he likes Toffee Towel very, very, very much. Now, Toffee Towel, if you would like to go, I don't know what about, oh, lettuce. If you would like to go, there are no lettuce restaurants. Okay, he says he will take you out into a field and you two can eat lettuce together as long as you don't like the communists. It's very important to him that you disclaim all affiliation with the communists. Ideally, you'll also condemn the communists, but at a bare minimum, you cannot be involved with the communists. Is this what you say to every woman or bunny? Well, they're technically female bunnies. Is this what you say to every woman you want to date? The first question you ask them is whether they're okay with disclaiming affiliation with the communists? Do you find this works well for you? He says it's his pickup line on Hinge. Who made you a Hinge? What is wrong with you, Pete Bunny Towel? All right. I think we know, Toffee. Listen, Pete Bunny Towel's high maintenance. He figured out how to make a hinge. You don't understand. He's a stuffed bunny and he made a hinge for himself. Oh, goodness. My life is a theater of the absurd. Anyway, the point is we'll be playing trivia tomorrow. Let's aim for after lunch. So 12:30, 1 p.m., maybe closer to 2. And then also, let's think about Wednesday. There's going to be a stream for the CCC public meeting. Please tune in early in the morning. I mean, it's not necessarily as important as some of these trials, but I want to get folks chatting. Maybe we'll do some trivia before the CCC hearing, mostly because I think people watching regulatory hearings, much like when we talked about the law earlier today that I'm working on related to the special prosecutor process, I think getting people engaged in how the quote sausage is made and the regulatory drafting process and the codification and sort of the nature of the Roberts Rules of Order and how the legislative apparatus interfaces with the regulatory apparatus and the bifurcated nature of an Article I court's function as both a rulemaking and adjudicatory body. Oh, goodness, ladies and gentlemen, so much to talk about. I think that's a great way to get people interested in our democracy, just like learning about the law earlier today that I want to write. Well, I already wrote it. I want to get it passed into law. And someone was like, Grant, are you telling me that people take you seriously to the point where you can just walk in there, tell them that you want this to be a law, and they'll do it? Yes. Yes, I don't do it that often because when I do it, they're like, oh no, Grant's here. Oh dear God, make him go away. No, I'm very amicable and friendly. Oh my goodness, ladies and gentlemen, look at what Allie and Rue sent in the towel chat. It is a super towel fox with a bullhorn shouting good luck. Oh, this has just made my day. Oh, you little super towel fox. I'm going to give you a little head pat. Look at him. Look at how excited he is. He is as excitable as I am when talking about the interactive, deliberative democratic process as made manifest in the regulatory apparatus or the lawmaking process. You don't understand. There is nothing I like so much. There's nothing that makes me as happy, and maybe this is not really a good sign. My eudaimonia or summum bonum as a human seems to be encouraging people to get involved in the lawmaking or regulatory process. All right, okay. Towel friends, it was a very good day to spend with you. God bless all of you. I went way over on my recap. We'll see you tomorrow for trivia. We will, hold on. 4 minutes. I will see you tomorrow for Towel Trivia, Wednesday for the CCC stream. God bless you so much. Thank you so much for all your support. And I kind of just melded the recap into my ending there. So again, public information service designed to engender and cogent public discourse. Thank you for all your support. See you tomorrow for trivia. Let me drop the links in the chat. Thank you for that super chat. I know some of you asked earlier, or LS, or someone was asking me what's the best way to support directly. If you want to feed Little Towel, go ahead, throw Little Towel a donation. It'll just go to server costs or whatever other bill I'm going to get. I need to pay my Pacer bill to get court documents. But anyway, this Super Towel Fox is amazing. Towel loves you all very much. Great to see you, Colleen and Allie and Peach Pie and Francesca Towel. And who else was in there? Everyone's under weird usernames because of the YouTube issue. Love 7 Loyalty, Bossy Texas Chicken, Bella, all of you so much. Thank you. I appreciate every single one of you for chatting today. Intense subject matter, but it's easier to talk about it with you all. Good night, Grand Peep, says Allie. Good night, Toffee and Rue and Allie and Commander Buck and Colleen Henry. And I'll end this way. This is a public information service. You know that it's designed to help others, but really, if you want to pay it forward, it's not about donating to me or subscribing or like, I don't really care about that. I want people to be informed and engaged, so I'm thrilled you're all here, but what I care about is you paying it forward. It's not so much like, yes, you pay it forward in the chat, and I appreciate all of your camaraderie, but what I want to leave you with, and why I do this at the end every day of the stream that when I'm live, is I'd like you, when you're not watching this stream, to just have an imprint maybe left on your mind somewhere, your soul, that when you confront a situation and you're given the opportunity to pay it forward, do you look for that opportunity to do an unconditional small act of service and show love and compassion for your fellow humans? Now, you know what I'm going to say. One of my favorite ways to look for opportunities to do that is donating to homeless veterans. We should not have one veteran in the United States of America that is homeless against their will. They want to go live in the woods, we're not going to stop them, but not against their will. That's wrong. It undermines the integrity of the United States. They served us, they protected us, and we have to do the same for them. Times might be hard, But that means that they're even more difficult for our homeless veterans, and we can support them, ladies and gentlemen. It's a bipartisan issue. Who is going to stand up there other than some damn communists and say they don't want to support our veterans? Towel loves America. You should support our homeless veterans. God bless you if you do. Second, what if you love animals? Towel loves animals, as you know. That's why I put them up on the screen so often. You can donate to animal shelters run by veterans. I know, I researched this. There are even animal shelters that take in dogs to train them to be service dogs for veterans. Genius. Now, say you can't find an animal shelter run by veterans. Have you considered donating to animal shelters in general? Everyone loves animals. Please do that. If you live in the UK, you can donate to The Big Issue, which is a way to help people experiencing homelessness. Really good operation. They sell newspapers. They become self-sustainable. Towel loves it. It's not communist. It's self-sufficiency. See what I'm saying? I hate the damn commies. Furthermore, you can also consider something like waving to a person on the street or smiling, reaching out to a friend or family member you haven't heard from in a while. Towel Nana called me earlier today. I have to call her back. And furthermore, it could be something as simple as donating 200 tomato plants to a friend and having them designated honorary towels, as Francis Frutrell did one time, forevermore. Yes, in that way, ladies and gentlemen, I believe we can bring about a new realpolitik, not centered on expanding, preserving, and demonstrating our power, but instead centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service rooted in unconditional love. In that way, we'll be able to find our towel summum bonum or eudaimonia in the Latin or the ancient Greek, respectively, living up to our greatest good, rippling out small acts of service outward into the universe, and therefore bringing about a new digital epoch defined by Aquarius the water bearer standing tall and carrying a towel. See, I've had a lot pent up, and I wanted to say it. God bless all you towel friends. I'm going to get out of here. I'm tired. Towel loves you very much. Have a great rest of your night. Thank you for being with me. My name's Grant Smith Ellis. I appreciate every one of you, all of your engagements, all your chats. Towel friends on the X and the YouTube, we're both signing off together today. Until I see you again, all 6,000 of you over on the X and all of you towel friends on the YouTube, can't express how much it means to me to have spent some time with you today. So glad you all got to catch up and chat. I'll see you for trivia tomorrow and then the CCC on Wednesday. My name's Grant Smith Ellis, and I love you all dearly. Until next time. Bye, towel friends on the YouTube. I did give you a few seconds extra because I love you all so much. Thank you for all your chatting today. You know how much it means to me. Until we see each other next, really, know how much you mean to me. I try to help you in your life. Maybe people in the chat you've met here have made your life better, and that's what I care about. Until next time, towel loves you, friends. God bless. Be well.